So, the Plaintiff's Exhibit 1 that's in evidence, the jury's seen the 2014 contract. It says D3M at the top. What is D3M and what is your relationship to D3M?
D3M Licensing Group, licensing company that secures brand ambassadorships, product placement in music videos. We specialize in the music space and licensing deals. We're Flo Rida's exclusive licensing partner, and D3M's one of these David Gold. There's actually 3 Davids, and the M was for my late wife Marla. And we started the company, I believe, the tail end of 2013, and Flo Rida was our main focus.
The contract, who negotiated this contract with Celsius?
I did a 2014 contract with myself and at that time their president CEO Jerry David.
All right, and I'm going to direct you to page 20. The jury has seen this clause many times, but just want to show you on the compensation provision. Who is it that directs?
If I may, a second. I apologize, everybody. My son's in the first row. Can I have my reading glasses? Yeah, getting older.
You can have mine.
Getting older is not fun. Might look fun, but in the movies, but it's really not. Thank you.
So, on page 20, there is a clause that the jury has seen many times, paragraph B, which talks about the shares when they're issued. Who directs Celsius how the shares should be issued? Maybe you can read this if it's easier.
I know that. That would be D3M.
Okay, so D3M directs how the shares are issued, and so we're going to go back in time. But right now, today, how do you want the shares issued? How is D3M directing the shares issued? What percentages to D3M and what percentages, on the other hand, to Flo Rida and Strong?
Okay, today Flo Rida is due 75%, and D3M's members are due 25%.
And this is for all of those shares, the 500,000 shares and the 250,000, correct?
It had changed slightly. The initial.
No, but I'm talking now. What at issue in this lawsuit is right below that paragraph. It talks about 250,000 shares if a bonus compensation, if certain benchmarks are met, and then another 500,000 shares.
Correct.
Right, and those have not been issued, correct?
Correct.
Okay, so how should they be issued?
They should be issued 75% to Flo Rida / Strong Arm and 25% to the D3M partners.
All right. Now I want to talk to you about the first time that you directed the shares to be issued, the date. This document is not in evidence, but I'm going to show it to you to see if it refreshes your recollection as to what the date was when you directed for the first time the stock to be issued.
Was this 2014?
No. We're going now to. Okay, let me ask you through questions to lead up to that.
Your Honor, let me just object as to the procedure. The first procedure is asking the question as to when, and then you can refresh his record.
Sustained. All right, ask your next question. Objection sustained.
I'm going to go back a little bit. So, Mr. Gold.
Yes, sir.
Look at me. We'll get to that in a minute if we need it, okay?
Okay.
So the question is, there in 2014, 15, 16, 17, 18, 19, did you direct Celsius to issue those 500,000 and 250,000 shares? And if not, why not?
The bonus shares we're speaking of?
Yeah.
Okay. They had told us, Jerry David specifically and John Fieldley, who at the time I believe was CFO, said that we did not meet the sales benchmarks.
And you wanted to get the data yourself at a certain point, right?
Yeah, so we had requested on many occasions, auditing and accounts and whatnot, and we didn't receive anything as far as numbers and accounting. But we were working very, very closely with them. I mean, I personally was probably at their offices 3 times a week, and I thought we had forged a great relationship, and Flo as well. We did a lot for them.
All right.
We believed him. I believe
So
him.
just to focus on this, I know it's early in the morning, but to focus on the dates. I should tell you, I promised the jury to try and go as quickly as he can.
Okay.
I won't interrupt you unless I have to. I guess since it's a witness on the plaintiff's side, I can interrupt him. And D3M is a plaintiff in this case, right?
Correct.
So you're my client,
Correct.
okay? And you won't get mad if I interrupt you just to try and keep this moving sometime.
You can. I was married 20 years. You can interrupt me as much as you like.
All right, so I just want to focus on you didn't have the data, you wanted the data. Did there come a time when you hired a lawyer to say, maybe a lawyer could get the data?
Yes.
And so on what date, do you remember the date that the letter was sent to Celsius on behalf of D3M and Flo Rida and Strongarm directing that the shares be issued? Telling them we want the shares.
The exact date, I don't recall. I believe it was 2020.
Okay, so if you don't remember the exact date, would the actual letter that was sent remind you of the exact date?
Yes, that was a
Okay.
freshman.
So now would you take a look at what's in front of you and tell us if that refreshes your recollection as to what date the share were
Yes.
demanded?
Yes.
What
It's
date?
February of 21.
February what?
26.
February 26th,
Of
2021. Okay, and then there was a response to that. Okay, plaintiff's 88, please. So this is now in evidence, plaintiff's 88, the response. I'm just asking you about the date though. When did Celsius respond and say, we're not giving you the shares?
April 30th, 2021.
Okay, so you can take that down. All right, so we've got February 26th, the shares are directed to be issued, correct?
Correct.
And then April 30th, 2021, Celsius says, no, we're not issuing the shares, correct?
Correct.
All right. Thank you.
You're
So let's go back to 2014. After the contract was signed, well, before the contract was signed, during the negotiations, what was your expectation as to what type of marketing would be marketing dollars from the company would be put into the promotion of the product?
the expectation was high. The category is a very, very strong category, and they were asking for us to give Florida give them exclusivity. Okay, so Flo could not represent any other drink in that space, and that's a big ask based on Flo's footprint and his celebrity status, and et cetera, et cetera. It should have been a seven-figure deal easily. Jerry David, presented to me.
Who is Jerry David?
Jerry David was the CEO at the time, and it was he and I that were negotiating the contract points. So Jerry assured me that we were better off taking less cash and more in stock. And I inquired about stock price, and it was like 20 cents a share on something called the pink sheets. I researched it. It wasn't very impressive. So I inquired as to that, and he
All
said,
right, but sir, let me just focus you on
Yes,
the
sir.
marketing dollars. What was your expectation?
So he assured us that they literally had a billionaire who was the founder of the company. I believe his name was Bill Momo. I never met the gentleman, and money was not going to be a problem.
All right, so now, and again, I'm sorry to interrupt, but I have several
understand.
topics. Let's just try, because I really don't want to interrupt you.
I
okay?
apologize.
I really don't. So, you thought there was going to be a lot of money behind it.
Correct.
Okay? The CEO told you in terms of putting money, not just floating out there, the company's putting money. What happened after the contract? Was there any money put into marketing this product, this co-branded product, these products?
Objection, Your Honor, speculation. I don't know. There's no foundation as to latest to what Mr.
All right,
Gold knows.
sustained. Lay a foundation.
Do you know if there was marketing money put into promoting the product after the deal? And if so, how do you know?
I was very hands-on, very hands-on. I talked to Trey 5-6 times a day and most of the staff. There was little to no money that went behind the marketing with Flo being the brand ambassador. We were promised billboards. That never happened for years. I think they did one. They were supposed to do online marketing, a whole host of things, and unfortunately, it ended up painfully obvious they were relying on D3M and Strongarm, Flo Rida's company, to handle the brunt of their job, the marketing, based on Flo's 25 million followers. It turned out at the end of the day, that's really what they were counting on. So at that point, we kind of realized, we're misled, but we were locked in.
All right, so now let's talk specifically about one example, because they've heard a lot about the NACS convention, the jury. What does that even mean? I don't know what it stands for, NACS.
NACS is National Association of Convenience Stores. It's one of, if not the largest trade show in the States, if not the world, for your 7-Elevens and your Publix and whatnot. And Celsius did not have a strong, what they call, footprint. They weren't in a lot of stores, okay? And our goal at that point, I discussed it with Flo and the Strong Arm team, so we're going to have to help them help themselves, as we're locked in. So
You're owners, right?
Yeah.
There was some initial stock.
Yeah, there was initial stock. We're equity shareholders, and there wasn't much of a cash component to it. As I said, it should have been 7 figures. Anyway, to answer your question, my wife and I had previous experience in retail and marketing, specifically with new products. We had some very strong connections. One of which was a board member of NACS, contacted.
Your Honor, just kind of drifting here. This is a long narrative.
Hang on, so objection there, sustained. Can I ask you next question?
Okay, all right. So the NACS conference has a lot of retail stores there, and it could potentially be a big deal for a manufacturer and retail company.
Objection.
All right. Overall, you can
Okay. So thank you. He actually did it. When there's an objection, wait until counsel argues.
I'm sorry, I've never
And
testified.
I know, and you can get through this. I know you're nervous. It's okay. Okay. You brought up your wife. Okay. Who signed the contract on behalf of D3M?
Originally my wife.
Okay. And what was your wife's role in
She was the sole managing member and the CEO and co-founder.
So people are going to wonder, so I have to ask you this. She signed the contract. She's the sole managing member. She's the CEO of D3M. Why isn't she able to testify?
We lost her in 2016. She was 43 years old. It was unexpectedly.
Okay, all right. I'm going to cut you off on that but I'm sorry to do that.
Yes.
Just to focus on admissible evidence in the trial. Again, I apologize, but I just wanted to get why she's not here. Thank you. And don't be nervous.
I'm not nervous.
We'll get through this. Okay. So we're talking about the NACS convention. It's potentially a big deal. How do you know that it could be a big deal for a company like Celsius? How did you know already at the time?
Because my conversations with Tony, was a board member.
Board member of what?
Of NACS, okay, and in charge
Objection,
of.
Your Honor, hearsay.
Overall.
He's a board member of NACS.
Okay, he hasn't said what he said. Our objections is overruled. What you're not allowed to do is say what somebody else said, but you may continue.
Understood you. Okay. So since we had a pre-existing relationship, he offered Celsius to exhibit at the trade show if we were to be able to lock Flo Rida in to do meet and greets, and we would get, Celsius would get extra large space and whatnot, and he would ensure, if we could deliver Flo Rida to the show, he would ensure that he would set up meet and greets with high-ranking decision makers at 7-Eleven, Publix, et cetera, to meet Flo personally and to discuss business with Jerry David, the CEO, on behalf of Celsius to expand the line.
Okay.
Your Honor, I move to strike that entire testimony. That is hearsay testimony of somebody else.
Overruled. All right, you may continue.
So, did Flo Rida appear? You asked him and say, hey, look, this would be great for Celsius. Did he come?
He not only showed up, he did more than was asked.
He did a concert?
We ended up, Flo did, graciously did a full concert at the VIP after party of NACS, held at the Hard Rock, and it was amazing. So you had worldwide decision makers, and we had a special VIP room after Flo was done with the performance, where we ushered the decision maker from 7-Eleven, and he met Flo, and Flo was like, wonderful, and he loved the product, and Jerry was there, and we helped close 7-Eleven, thousands of stores, and that was just one.
What in that? Yeah, so there were others too, not just 7-Eleven, right?
Sure.
But just talking about 7-Eleven, one of the ones that you closed at NACS, what did that mean in terms of the retail space for the product, the amount of stores it's in?
Oh, it was amazing. 7-Eleven is broken up into franchise stores and corporately held stores. So, and the thing with drinks is positioning. As we all know, you go to whatever, you go to 7-Eleven, in the refrigerated section, you're reaching for whatever. So Celsius had a lot of trouble getting proper placement because they weren't known as well yet.
Okay,
So that helped the placement.
Just to focus on him getting out there, okay?
Oh, yes.
Just people might think, maybe the videos give this impression that it's just him sometimes, but like to put on a concert, how many people got to get out there?
Oh my goodness. We have Flo, we have his band, we have his front of the house engineer, back of the house engineer, the dancers, security. It's a lot. It's a big undertaking.
Just for flights and hotels and meals, it costs some money.
Yeah, the logistics. Yeah.
And the NACS conference itself, the exhibiting and all of that costs money.
Absolutely.
Right. Now, so Celsius getting the benefit of NACS, who would you have initially expected to pay for all that?
Celsius, graciously, I thought would pay for it.
So they either they didn't have the money or they didn't appreciate the opportunity.
Objection.
All right, sustained.
Why didn't they want to pay for it?
Jerry, my conversation with Jerry, David, after I let him know we'd have the VIP meet and greets and all that stuff, and Flo was going to perform, said, well, if you believe in it so much, okay, why doesn't D3M share the cost? Which is very unusual. But at that point, I spoke to my partners in our corporate office in New York. I said, look, we have no choice, right? We like the product, but if the stock's going to go up, it has to go into more retail stores. So fine, we agreed. I think it was a 60-40 split. Celsius paid 60%, and D3M paid 40% of the hard costs for everything.
So that's a good point. You were mentioning that, like, if the stock's going to go up. If the stock doesn't go up, right, does this deal make any sense for you guys?
No, not at all.
All right, now let's switch to, and I want to try to do this very briefly. There was a birthday party with Flo on a yacht. Were you there? Right after the contract was signed.
Yes, I threw the party that's one of the things we do.
Okay,
for Flo.
and it was in Miami.
Yes, it was it was Revolt, which is a big party conference that Diddy throws. And Flo, we were celebrating and launching My House track, and I had been introduced to Russell Simmons short time before that, and it turned out that Russell was already drinking Celsius because he's into health and Yogi Master and all that, and he expressed interest to me that he wanted to get involved with the company. and Russell just by happenstance called me. He's like, I'm in Florida. Where are you? I'm like,
Your Honor, objection in anticipation that he's going to make hearsay statements.
All right, objections overruled.
so.
Just try to focus.
Okay. To cut to the chase, I apologize, everybody. To cut to the chase, Russell called me. I'm like, I'm across the street on the yacht with Flo. And Jerry David, the CEO of Celsius, is here. He's like, meet me in the lobby. I'm coming over. So I met Russell, and I brought him over.
All right, so let's go one by one because I want to make sure we don't. You don't say. We have to be careful about hearsay and other things. So listen to my question. On the vote for Celsius is who?
From South, Jerry David.
Okay, you got Jerry David,
CEO.
who the jury's going to hear from this afternoon, and you've got you're there.
Yes.
Right? And is Flo Rida there?
Yes.
Of course. All right, and then who came with Russell Simmons?
Russell had, I apologize, I forget the name off the top of my head, a high-ranking executive of Pepsi.
Okay, and did you and Flo Rida tell any plan, and if so, what plan, in your mind, your vision for Celsius to Russell Simmons and the Pepsi executive on that yacht?
Yes, we had, as you can imagine, it was quite loud, much going on, but we got some alone time, Flo, myself, Russell, and the gentleman, and to strategize a little bit. And Russell indicated that he was...
Wait, I apologize. I don't want to hear what Russell indicated because we have to go by the rules of evidence. I know you don't know them. So
I don't know them either.
Don't. But what was the plan that Flo Rida and you told Russell Simmons and the Pepsi guy about what your thoughts and vision for Celsius, your plan?
Thoughts and visions were, since Russell is basically known as the father of hip-hop and Flo's one of the top 10 hip-hop performers of all time, that we team up. The company needed cash badly and marketing, and Russell and his guest response was,
Wait. I'm not even. We're not going to ask the response.
Okay.
The jury. I think it's already in evidence. It certainly will be about what happened after that.
Right.
But what he said is not evidence.
Okay.
You told us the plan about you that for them investing. But what about for the future of Celsius? What did you see the future of the company?
For the future, and some of it came from me, some of it came from Russell. He was very excited to work with Flo, and I believe Flo was very excited to work with Russell. It just made all the sense in the world. And he also had a relationship with his ex-wife. They were close, so they were going to bring Kimura in, and they were bringing a gentleman in by the name of Lee Cushing.
Let me stop you there. That's exactly what I talked about. So that is legal. expansion. Okay, but let's just start. Who at Celsius said this was a renewal?
Jerry David. He
Okay,
CEO.
and who else? I'm asking for names.
John Fieldley,
Okay, who else?
Vanessa Walker.
Who else?
Those are the top three execs.
Who is Howard Wishner?
Howard Wishner is from Wishner and Associates. He was hired by Jerry David directly because he was an expert in marketing.
Directly to do what?
To work with me on the renewal to add some additional what we call deliverables.
And did he use the word expansion too?
Yes.
Did anyone ever, during all this time, tell me the name if there was anyone at Celsius who ever said this was superseding or canceling instead of renewing and expanding?
No.
All right, let's talk about the word units. You have experience, you mentioned before something about your experience. What type of experience in retail selling do you have?
Prior to entering the licensing business exclusively, the Brand Ambassadorship, I have about 10 years experience in, after I was overseeing Shark Tank, kind of in that space, so identifying our client base was mostly new inventors that had new products and patented, and we were looking for the next big thing. So again, my wife and I owned that company. We worked together the whole 20 years, and we would choose what we thought was one of the best products, and then we would be in charge. We had a film crew who filmed what now everybody's streaming, but when TV was TV.
So just it's like a 2-sentence summary. You have some experience in selling products.
Absolutely. We did their campaigns, direct TV campaigns. If it sold through well on a test, we had the results to show Target, Walmart, Walgreens, hit the test, and then you get your initial order and you go from there. But yes, that's...
Do you know the things like UPC codes and SKUs?
Yes.
Okay. All right. So you aware that the sticks have a UPC code?
Yes.
And by sticks, I mean, for the record, the powder product that Celsius sells on-the-go sticks. What is a UPC code?
UPC code is just, it's the barcode. Okay, it's every product has it. Okay. It's,
Well, wait. When you say every product, if I buy something that's not meant for individual sale, does it have a UPC code on it?
yes.
For what reason? Isn't the code what the cashier scans?
They're all unique. Okay, the UPC codes. Okay, so if you're gonna, if we say in the beverage space, if you go to buy a 12-pack of Coca-Cola cans, the UPC code is going to tell the system we just sold a 12-unit case of Coca-Cola for inventory purposes.
That's a good point. Okay, so, but let me ask you 2 questions about that. The first thing is there's one UPC code for a 12-pack that is only sold as a 12-pack, correct?
Correct.
And that's what the cashier scans.
Correct.
And what does the UPC reflect in terms of the data in the computer of units sold?
It would
Yes,
say.
Your Honor, I mean, we're speculating as to what some unknown computer registers for what product.
All right. I'm going to sustain the objection if you want to just clarify.
Okay, so based on your experience in the industry, why is it important when the cashier scans a product at checkout that the company gets certain information rather than just the price of the product, right, to the customer, right? What is being tracked?
It's twofold. It's one for inventory purposes. They don't want to run low on inventory, and also tracking how well a product is selling.
All right, and so if this the only reason this could have a UPC code to be scanned is for what? What reason? What will happen to that UPC code?
It'll show that one individual unit was sold.
And when it's bought by the customer?
Correct, when it's scanned.
Okay. And so like even another product, a 12-pack, a 24-pack, those are 24 units.
Yes.
Okay. Do you know what SKU stands for? Not everyone knows that.
No, the UPC was unique pricing code. I forget the acronym on SKU, but to be quite frank,
Okay, I'm not gonna, I don't want to lead you on it, but a lot of people in the industry I found don't know that. I didn't know it, I had to look it up. What were your marching orders from Celsius in regard to the Flo Rida branding the cans, the ready to drink? What were your orders from Celsius? I used marching orders because I read your deposition.
the marchers became more and more aggressive to focus on what they call the RTDs, which is a fancy way of saying ready to drink, the cans. And they had just less and less focus on the powders.
And is that what you did? Then you switched to the can?
Flo was gracious enough to focus a lot more on the cans. We did product placement outside the scope of the contract. The My House video, for instance, which ended up, as I was saying, we didn't know at the time, figured it would be a hit, but it was a hit. It was quadruple platinum, and the video got, I forget the exact number of views, but hundreds of millions of views. And Flo did, when you do product placement, that's a business of in and itself. With the celebrity, you charge for that, big money. So if the product would be next to Flo Rida, that's a certain amount of money. But to get just drinking, he just held it, boom, for everybody to see.
And it wasn't, but he did that. That was his choice. He wanted to do that, right?
Yeah, Flo did a lot of things independently.
Yeah.
Yes. Yeah.
I'm not. The only reason I'm saying, trying to draw that distinction is, blame's not the right word, but responsible. Celsius, we can't hold Celsius to what he did. In other words, their intentions. That was up to him. He wanted to do it. He wanted to help the company. But were there also things that the company put out, right? First of all, they were happy about that, right? The My House video.
Yeah,
right?
I was there actually. I was physically there. So,
All right, but what about their own ads, their own social media, their own things that they were putting out with Flo Rida holding cans and of all flavors, and did they do any of that?
We would provide them with what we call digital assets. Okay, so we had photographers, professional photographers and videographers that worked with Flo that Flo was comfortable with. That would take video of Flo working out, and with the Celsius co-branded shirt on, and drinking it or using the powder or whatnot. Some stills, some videos. Okay. Flo would instruct us to post to a social media director, post them.
I get that, but let's focus not on what you guys posted. Okay, you said you gave them content.
Yes.
I want to talk about what they did. Okay, so we can say, look, this is something they were doing. That they were, if they have Flo Rida and Flo Rida's brand, and Celsius brand, that they posted, that they put up billboards. Proven, beat, right? What did they do with Flo Rida and the ready-to-drink cans?
Question a little bit leading, George.
Overall.
They didn't do much themselves. What they did with the assets we gave them is, I believe we did on a monthly basis. Also don't want to oversaturate, the followers. So their marketing department would send us a desired post with verbiage
so you
for
may not
us
know
to
this
post.
it's great, and the jury has already heard about all the posting and the things, a little bit about that you guys were doing. But do you know, if you know, what they were posting? That had Flo Rida, it might have been content you gave them, maybe it wasn't. But Flo Rida, his brand, his likeness with cans.
They would repost what we posted.
Okay.
Let us know.
And do you know, is that all you know? Anything else you know about
there was
that?
some in-store GNC. There was some in-store displays.
Okay, displays of what?
Flo That the one I was familiar with at GNC was Flo, right after a workout, holding one of the powdered SKUs, the tub.
Okay. The can, if any, and if you don't know of any, just say, I don't know of a single one, but do you know of things that they posted, promotions they did with a can and Flo Rida?
Yes, they had posted things and had collateral materials. I don't recall which retailers they used them for. And
So
what.
there are things in evidence that the jury has already seen and that
Right.
we can show them. All right, my last topic. We have to talk about, your party in this case, we have to talk about the statute of limitations defense that's pled in this case. And is going to be on the verdict form, which is the idea that you waited too long to sue. So in 2014, for 2015, 2016, 17, or 18, or 19, did you have any data that suggested that the benchmarks for the 250,000 in stock and the 500,000 in stock had been reached? Did you have any data suggesting that?
No, I would never received any reports. As I said earlier, I asked, and the answer was on Jerry David's watch as CEO was failed miserably, and then John Fieldy went from CFO to CEO, and on his watch when I inquired, he said, no, it didn't go well, there's no use in even sending you the numbers.
So, and you never got the numbers?
No, we did not.
Okay, and you said that you were told it was a failed product. How did you come to find that it wasn't a failed product, that it was still on the shelves, the powders?
Actually, by happenstance, my son was on a trip with his girlfriend at the time, and they went into a vitamin shop and saw the powdered
Your
sticks.
Honor, this is going to call him for hearsay because obviously he wasn't there, and so he's recounting what his son told.
But it's not necessarily for the truth of the matter.
Members
Your
of the jury,
Honor.
you're not to consider this for the truth of the matter asserted as a substantive evidence, but rather the effect on the listener as to why this witness may have done something. You
Your
may
Honor,
continue.
This is also subject, we can take sidebar, but this is also subject to motion to be removed.
All right, objection is overruled. You may answer.
I think it's my last question, but I can't remember. Did you answer?
I started to.
How did you know that the product was it wasn't a failed
Yes.
product? Look, let me back up 1 second, okay? When you were negotiating this contract in 2014, it says in the contract they're going to create a powder product, correct?
Correct.
Okay. And so, when did you learn that a powder product was still being sold?
My son, handsome guy in the front row over there, was on a little mini vacation with his girlfriend, and he happened to be into a vitamin shop, and he saw the powdered sticks.
And by the way, were they being sold?
Yes.
All right. So last question, and that's when you started trying to get the data.
Correct.
More with lawyers and stuff.
Correct.
Okay. That's all I have. Thank you, sir.
Thank you.
All right, cross-examination?
Yes, sir. That's what we're moving direction.
Okay.
May I, Your Honor, just have one request. These are a little strong. Could I please swap? David, can you please give my reading glasses?
If you have them. These are.
I apologize.
These are grayness. These are.
Oh, yeah.
Right, they're made.
Yeah, I
Are
apologize.
there going to be any reference to exhibits? I think. Oh, they're asking.
Yes.
Okay.
Oh, much better.
All right. I just switched it over. So
How does it look?
Morning, Mr. Cole.
Good morning.
Good to see you.
But
You ready?
yes,
Just a couple of things, some follow up on what you just testified. First of all, you're not anymore Flo Rida's exclusive licensing agent, correct?
correct. We have an open-ended contract.
I'm sorry?
We still have an open-ended, non-exclusive contract.
Right. But right now, you're not representing him in any capacity, correct?
Right now, we have no projects working.
And you don't have any understanding with your strong arm Flo Rida with respect to the sharing of the proceeds of this lawsuit, if in fact there is a result in the verdict.
Yes, we do.
You tell the jury what that is.
It's the same I said earlier, 75% to Flo Rida and Strong Arm and 25% to D3M's members.
And you're not suing for the actual shares of stock, you're suing for damages, right?
My understanding is we're showing for the shares of stock.
Okay, you understand that your lawyers have said that you're not suing for the shares of stock, you're suing for damages. You understand?
I understand that there's different laws and whatnot, and we're limited to, I guess, putting a dollar amount on it for whatever reason. And I, yes, have been informed that it's a dollar amount.
Okay, so it's a dollar, so
Correct.
we're not talking about you're going to get shares of stock or anything like that.
Initially, that's what I thought. But
All right. Initially, that's what you thought, but now you understand that that's not what you're doing.
my understanding is that it will ultimately be a dollar amount.
All right. So, you talked a little bit about, you had a very close relationship with people at Celsius during the time that both agreements were in place, 2014 and 2016, right?
It's almost a full-time job, yes.
You were there a lot of time, weren't you?
Correct.
And you got very close to the people that were there.
With some.
And if you wanted to, you could have asked them, hey, could I have access to the sales data, right?
Yeah, I apologize. Could you repeat the
If
question?
you wanted to, you could have asked them, hey, can I have access to the sales data?
The sales deck
Data.
data. No, I had asked, and it was the same answer. It's not necessary. My relationships, when I got close, for instance, John Field, who's now the CEO, when he was CFO, we became very, very friendly. And he was very concerned because CFO without money doesn't have much to do. So he was a very big advocate of us and what we're doing.
So let me ask you this. Did you send them in, you didn't send them any emails asking for the sales data, right?
Just for updates, emails asking just for updates in general.
And they would provide you those updates, right? They would say the product wasn't doing well, right?
There was always, always the same response, product's not doing well.
And you didn't doubt them. You didn't say, well, let me see the sales data to confirm that the product is doing poorly, right?
No, I did not. I believed it was doing poorly, but I, quite frankly, as the licensing director and reporting directly to Flo and Strong Arm, I was upset because, to be quite frank, Jerry David and I kind of butted heads a bit. I'm like, where's the marketing that was promised? Where's the marketing dollars? That's why there's no sales. I visited Vitamin Shop many occasions, and the product placement was just awful. You could hardly find it, and there was the displays that were supposed to be there with Flo's picture weren't
You
there.
knew when you entered into this transaction that Celsius was a small company, correct?
I knew that they were big, okay, at one point, and they had a failed launch, and now Jerry was new. They brought in new management, and Jerry David told me when he pitched me initially to get Flo Rida exclusively. He is a turnaround specialist. It's a new day. The company, had amazing product, which I agreed. I read the 6 clinical studies. It was healthy. Flo liked it. And then we had the assurances, it's a new day. And as I said, he had told me the founder was a billionaire.
But you knew when you approached Celsius that Gary David was a turnaround specialist and that the company was going to have some challenges or had experienced some challenges in being successful, right?
I actually didn't approach Jerry. David
You didn't approach
us.
Jerry?
No.
So John Bergerano on your behalf didn't approach Jerry?
John, I got a call from John Bajarno, First American Alliance, I believe, telling me that he had a client, the name of Celsius, that was interested in engaging Flo as their brand ambassador. John at that time was not aware of our existence. Through a few degrees of separation, he wasn't direct to Flo, but he got through to strong arm, and then he was instructed, or he was informed that, no, you need to go through D3M because that's Flo's exclusive licensing partner. So
John Bergerano was not working on your behalf according to your testimony.
we ended up working jointly, but when he approached me, he said he was calling me on behalf of his client, Celsius.
I see. So he wasn't calling. So basically, he was acting as a middleman. He was trying to cut a deal, and he was trying to put both of you together, both D3M and Celsius together.
At the end of the day, unfortunately, it's what it turned out to be, but that's not what he represented initially. I apologize, but he did say Celsius was a client. They've expressed interest. You have Flo Rida exclusively. Here's what the company does. Here's what it is. Are you willing to enter into conversations with them?
Let's talk a little bit about the Russell Simmons and the whole testimony about the introduction of Mr. Simmons, his ex-wife, and Lee Kai-Shen, et cetera, et cetera. You were paid $400,000 by Celsius for that work that you did, right?
We were paid.
You, D3M.
D3M received monies.
Not Flo Rida, not Strong on D3M, right?
Correct.
And that was, you were acting as a consultant for Celsius in that regard, right?
Correct.
And in addition, you wore different hats during this 2014 through 2018 period, right? You were also a sales representative for Celsius, weren't you?
Much earlier, unfortunately. I didn't want to wear that hat, but
So
yes.
you were a sales representative, so you had access to Celsius sales data as a sales representative, right?
No, I didn't sell to retail stores. I didn't put purchase orders, get purchase orders or anything. I just identified opportunities.
But you would have had access if you asked as a sales representative of Celsius, right?
No.
You never asked, right?
I apologize. Ask what?
For the sales data, when you were wearing your sales representative hat of Celsius.
I wasn't out there, quite frankly, peddling Celsius. I was just using some of my connections that I had in the space. And they knew that Flo was our client and representing Celsius to see if there's a level of interest. And then I would hand it off to Jerry. I believe we had one document in place that had a nominal commission structure. I think it was like 5% or something like that on one agreement.
Let's talk a little bit about, we're talking about, the SKUs and the PCs and what cashiers do with products. You agree with me that Celsius doesn't sell directly to consumers, right?
I thought they did sell to consumers at some point via online or Amazon or whatnot.
But that was before your agreements, D3M's agreements with Celsius, right? At no point in time during post-2014 did they sell directly to the consumer.
I was under the impression they sold through Amazon directly to consumer.
But they didn't sell directly to the consumer. In other words, they didn't sell directly where somebody would be scanning the product and the consumer would be buying that product from Celsius, correct?
My understanding is that would have been an Amazon buy.
So Amazon buys the product from Celsius.
I don't know how Amazon's
You don't
infrastructure
know how
works.
that works. Okay. So let's talk a little bit about your background. First of all, So the D3M company was started by you and your wife, correct?
Correct.
And that was around 2012, 2013?
Yeah, that's more like 2015.
And before that, before you were living in Florida, you lived in New York, right?
Correct.
And if I recall from
Long
your
time ago.
deposition testimony, you went to high school and then you got a Series 7 license, right?
Correct. My
Okay.
early
Can you explain
20s.
to the jury what a Series 7 license is?
It's a stockbroker exam. It's a license to be a stockbroker.
So you were a stockbroker at one point.
Yeah, my early 20s.
Okay. But you're not a stockbroker anymore.
Oh, no.
And when you were a stockbroker, you obviously were familiar with researching public companies, right?
To an extent,
I mean, you know what a 10K is, right?
yeah, it's a filing.
Okay. It's a public filing. It's accessible to anybody, right?
I don't know about anybody, but I know it's a filing with
It
the
was
SEC.
accessible. It was accessible to you, right?
I never pulled up K's.
Do you know how to pull up a 10K?
I would Google at this point now, but back then, I mean, it was a long time ago. We're talking in the early 90s, where, you just had, a kid, you had a cubicle, and your manager just came out and said, okay, here's stocks we're recommending, and here's the analyst reports, and this and that, and they provided the diligence.
You know how to read a financial statement, right?
Fairly well, but I'm not a CPA.
I mean, you would need to know how to do that in order to be effective in the business that you perform, correct?
Stockbroker.
Yeah, you're learning.
You needed to know, unfortunately, you just needed to know the basics, and depending on what was being sold. I wasn't a bond expert. Okay, you need a lot more knowledge to be a bond expert. I wasn't an options expert. You need to know a lot more.
But is it safe to say that between 2014 and 2018, you could have accessed those public filings if you wanted to see how well Celsius was doing financially, correct?
No, actually. One of the things that John had told me, because I was fairly persistent for a while, and keep in mind, I'm also juggling the clients, and I didn't want to look also bad to Flo. I made a bad decision because we believed in the product. But there was a few times that I'd asked John when he was the CFO, and at that time they were still on what's called the pink sheets, which is very, very, very low level. I guess you're technically public, but it's non-reporting. So they don't have to report the financials. They don't have to submit, like you were saying, the case and whatnot. So I believe that wasn't
But that changed,
able to be
that
pulled
changed
up.
later, right? It was
much later. When they went to NASDAQ, that was after the Simmons Group and China.
But it was still within 2018, before 2018, right?
I don't recall the date that they went to NASDAQ.
We talked a little bit about the arrangement that D3M had with Strong Arm and Flo Rida. This contract, this arrangement, this was a contract between D3M and Strong Arm. This didn't involve Celsius, correct?
Which contract, sir?
The division of the proceeds, the 75-25%, right?
For this suit, you're talking about.
I'm sorry?
For this action, you're
No,
talking
I'm talking about in general. Let's take a step back. Before the 2014 agreement, D3M, or its predecessor company, entered into a contract with Strong Arm and Flo Rida to
Correct.
provide licensing services, correct?
Correct.
That agreement didn't include Celsius, correct?
It didn't include any companies. It was our exclusive agreement to represent Flo Rida.
Right, just you and Flo Rida.
D3M and Flo Rida. Yes, it was a master contract.
Exactly. All right. And you were basically retained by Flo Rida and Strong Arm for the purpose of securing endorsements for Flo Rida, correct?
Actually, no, we're not retained. We weren't retained. As a matter of fact, we actually gave a good faith. I'm a firm believer it gets skin in the game. If you talk it, you got to walk it. So we actually gave Strong Arm a $100,000 advance on business we hadn't even created yet. That's how much we believed in Flo, in our abilities. So no, they did not retain us. We were partners, and to show respect, we were very happy that Flo chose us. We weren't, honestly, I'm not going to sit here and say we were a major licensing company. We weren't, but we were passionate, and there's a friend in common that my wife knew, who's with us today, Mr. Goutet, and that's how it all started, really.
So you're familiar with the confidential letter of intent that you executed, or your predecessor company, which later became D3M, executed with Tramar. You familiar with that document?
I mean, there had to be LOIs and whatnot. I'm not an attorney. I didn't handle the paperwork.
Let's go ahead and show you Plaintiff's Exhibit 104, which is already admitted. Okay. Let's take a look at this document, and let's go to the signature line, signature page on the second page. So this document was signed by your wife, Marla Gold, correct?
Correct.
And she was acting as the co-president of Global Merchandising and Promotions LLC, right?
Correct.
Okay, and that was the predecessor name of D3M, right?
Technically, yes.
Okay. And so let's go back to the first page of this document, and let's look at the purpose of this document. All right? Let's read that there. Purpose is to enter into an exclusive worldwide agreement as Flo Rida's merchandising, licensing, and promotional agent with respect to artist indicia of the performing artist known as Flo Rida. See that there?
I do.
Okay. And then in addition, it provides for exclusivity. It says during the term, licensing agent and only licensing agent, that's D3M, shall be authorized to negotiate prospective licensing, celebrity endorsement, and other global merchandising and promotional transactions on behalf of client with respect to the artist indicia, right?
Correct.
Okay, so the idea here is you're getting an exclusive on behalf of Strong Arm and Flo Rida to go out and to try to negotiate licensing deals on their behalf, correct?
It was licensing, brand ambassadorships, events, anything to do with the Flo Rida brand.
It was everything, and this is
Everything but music.
exclusive.
Everything but music.
Everything but music.
We didn't
All right.
touch music. You didn't want me touching music.
And this was signed,
Okay.
let's go to the second page, this was signed on February 18, 2013?
That's what it says, yes.
So this is pretty much almost a year before the 2014 agreement with Celsius, right?
The initial agreement?
Yeah.
Yes.
All right. And according to this document, $100,000 was paid to whom?
To Strong Arm.
Okay. And then on the paragraph 9, we have the percentage splits that you discussed already.
They differ.
Okay. There's 75-25 if you bring the deal, and it's 65-35 if Strong Arm brings the deal, right?
No, it's reversed, sir.
I'm sorry, you're right. My apologies.
Not a problem.
D3M gets 35% if it brings the deal.
Correct.
And then if Flo Rida or Strong Arm brings the deal, D3M gets 25%.
Yeah, so somebody approached Flo or his manager when we were on the road or at an event and expressed interest in doing a licensing deal, brand ambassadorship, then they would turn it over to us. But since we didn't have, obviously, expense to go find the client, then the percentages went down a little bit, justifiably so.
And as a general matter, is it correct that when you would structure a deal on behalf of Flo Rida as the licensing agent, all the monies, all the benefits of that deal would first flow through D3M?
Yes, generally we were responsible for making sure that the receivables came in, it was escrow or the first payment and whatnot. Because in this business, there's unfortunately a lot of false statements going. People make promises and they commit to something, and then all of a sudden they're like, "No, let's just do a rev share deal." And so to spare Strong Arm all that, to answer your question, yes,
So this was your way of assuring that the money was going to be paid, or the benefits of the contract were going to be paid by one party to the other party. You control the money.
Well, we were custodians of the money because we didn't want to, bother Flo or Mr. Freezy Prince on something that hadn't actually been facilitated. Okay.
And this would include, for example, not only cash, but it will also include the shares of stock. You would direct how that stock would be distributed, right?
Yes, we directed based upon our splits.
Your Honor, could we approach Herman? I think we need to clean that up.
What is this exhibit number? This was plaintiff 104.
Yes, it's 104.
Are you moving it into evidence?
I'm looking at our list
If
right
it's
here.
not
I don't
in-
see 104 on it.
No, this was, it may have been on an earlier list. It's not in evidence.
Okay, well,
That are in
I
evidence.
have notes that say they're in evidence, but if you say there isn't,
Your
A
Honor.
new objection, Your Honor.
just let me know and I'll be more than happy to move it into.
all right, let's keep going.
Am I allowed to ask a question? Okay.
Gonna listen to the question, answer it, and then when it's all done, then your attorney will have a chance to ask some follow-up questions.
All right, Mr. Gold. So, would you agree with me that D3M would never enter into an agreement for the services of Flo Rida without putting them in writing?
Correct.
And before D3M enters into any agreement, it would seek out the approval of either Mr. Dillard or, in this case, Strong Arms representatives. Right.
Correct. Well, everything, the protocols were, I would, my primary contact was Mr. Reggie Mathis, who is attorney for Flo Rida and Strong Arm. So my protocol was go through Mr. Mathis first. If he agreed that the deal made sense, he would then bring it to Flo and Flo Rida and Lee Prince. And if they agreed, then I would receive an email or a call from Reggie saying, okay, proceed. And we would start to what we call paper the deal.
And it's your typically, and by the way, you testified earlier that you handled the negotiations with respect to the 2014 and 2016 agreement, right?
Just, for clarification, I handle all the negotiations, but when I'm negotiating, I did not have the authority to authorize the deal point. So, I would do the work of all the negotiations, knowing Flo's value, and expectations that Strong Arm had of us, and then I would forward a bullet point email to Mr. Mathis saying, here's what we've negotiated thus far. Okay, can you please run it by Flo and Mr. Prince? And sometimes they came back and they said, no, it's not. You deserve it.
And so
You need more. Sometimes they said it was fine on its face. But yes, I did the negotiations, but was not empowered to commit on Flo Rida or Strong Arm's behalf.
And so, in order to facilitate so that there would be no misunderstanding of what the terms would be, generally your practice to enter into memorandums of understanding or letters of intent to kind of set forth what the basic terms of the deal would be, right?
As a rule, but a lot of them changed as we entered into relationships. A lot of it became we're very close knit. Okay, the clients and the Strong Arm family became, quite frankly, family. My children grew up with them and whatnot. So it was not uncommon after a deal had started, the client would want additional deliverables, or Flo would see an opportunity to on the road, and I'd get a call, and he would like the My House video with Celsius. That wasn't, we didn't do any paperwork on that. It was just something that he decided to do. He did. It was extra value for the client. So, so a lot of times we went off script sometimes at the benefit of the client.
But in this particular instance, you didn't go off script. In both the 2014 agreement and the 2016 agreement, you went out of your way to prepare memorandums of understanding so that there would be a summary of the terms that were agreed to by the parties, right?
The initial, but we went way off script during the extent of the relationship, above and beyond. A lot of
That's
things.
right. Because in the second agreement, there were a lot of changes to the terms compared to the first agreement, right?
No, actually, I wouldn't call them changes. There's one agreement. The 2014 agreement was the agreement. Okay? There is provision for renewal, and there's a timeline on renewal. So I contacted Jerry David, and Flo was getting bigger and bigger and bigger. So I wasn't worried, quite frankly. But I said, if you want to renew, we need to know. If you don't want to renew, we need to know. And then he said, give me a little bit of time and to call the board. He called me back within a few hours and said, we're definitely going to renew.
All right, we're going to get back to that. I'm glad you raised that as a point, because I do want to ask some questions about that. But let's kind of keep the chronology so we don't lose the jury.
I'm sorry if I'm boring.
That's all right. No, like you said, this is your first time, so we'll go through this slowly. We don't want to confuse anybody. So let's go back. I want to focus now on when you started the negotiations for the 2014 agreement. So let's go ahead and, Scott, you can put up Defendant's Exhibit 6, just the first page. I don't want to go through anything. Now, Mr. Gold, you negotiated the 2014 agreement primarily with Mr. Jerry David, correct?
John Bajano started, apparently without our knowledge, and then I took over, yes.
And you exchanged a number of emails with Mr. David, where you and Mr. David went back and forth over terms, the various terms that you were requesting, and then the various terms that Celsius was requesting for this agreement, correct?
Yeah, we have mostly a lot of face-to-face meetings because they weren't too far. They're in Boca, and I was based in Wellington.
And I know that the top email is an email from John Fielding to Jerry David, but below, the page below, we're dealing with, this is an email from you, from your D3M group email address to Jerry David, correct? And then if we go to the next page, Scott, we also have emails being exchanged between Mr. David and you and your wife and Darren Hopkins, as well as John Bejarano. There's isn't that name yet, right? And we'll get to February 20, 2014 email.
I appreciate your response.
We'll go through these emails in a second. I just want to make sure that you're acknowledging these emails you received.
There's probably thousands of emails over the years.
There are. All right.
Yeah.
And then let's just go to the next page. There's another email from you to Mr. David, also David. It looks like there were a lot of emails on February 20th. A lot of big exchanges there. See that?
I'm looking at it.
You don't have to read it. I want you to focus on the date and who the recipients are.
I was just looking at the content just to make sure
Okay.
that I indeed.
So let's go to the first email, which is.
Let me ask you, what exhibit is this?
This is Defense Exhibit 6.
Okay, we do not show that at
And we're going to
being
introduce it in evidence right now, just lay a foundation.
Okay.
Your Honor, I object. If he says it's in evidence, I'm not even looking at it. I would like
All
to
right.
see if I have an
Hang on.
objection before.
All right, it's Defense Exhibit 6. We'll take a look at it. It's being offered. Any objection to Defense 6?
Are there any objections?
Can I take a look
What's
at
the
it?
base number?
This is Defense Exhibit 6, starting with page number 1794.
We have a hearsay objection to that exhibit.
No, these are emails between Mr. Gold and Mr. Jerry Davis.
Right. This is
Your Honor, I object to this procedure. I haven't even seen the document.
okay. Take a look at it. Actually, this is probably a good time to mention this. Mr. Director, I forgot to mention this yesterday. We have a celebration of life for we lost one of our colleagues this week, and so I'm up on the 17th floor at lunchtime. So we're going to take a little longer lunch. We're going to break at about 11:45, and so there's not going to be lunch for you back here today. So we're a little bit longer. What I was hoping to do was go without a break this morning, just to go to 11:45, and so ordinarily I would have taken a break to send you back and could have taken care of some of these issues, but we're going to go for about 30 more minutes, all right? And then we're going to break and have a little bit longer lunch. All right, has
Your
Mr.
Honor, I
Slavy had a
do not
chance?
object to anything that was said by this witness in email. There are internal company communications that are hearsay between different individuals at the company, between each
All right,
other.
so
We do object to
let me
the
do
document.
No, the only
I'm
internal
going-
communication.
I understand. Let me do this. All right. Plaintiff's exhibit, I'm sorry, this is defense. Defense exhibit 6 is in evidence, however, it's subject to potential redactions of, and y'all can work that out afterwards if there's anything that, the main part, these emails here are from this witness, Mr. Cole, and he's a party, so these,
Right, we do not object to anything that he says.
all right, so this is in evidence. Take a look at it later and see if there's any parts that need to be taken out. All right, defense exhibit 6 is in evidence, subject to any later redactions. All right, you may proceed.
So let's go to the February 7 email, 2014, from Mr. Gold to Jerry David. So this is the first email in this string of emails, Mr. Gold, and feel free to review it if you want to refresh your memory on the contents, but is it fair to say that this is one of the initial emails that you sent to Mr. David concerning what B3M was looking for in connection with an endorsement/brand ambassadorship agreement with Celsius?
I don't recall if if you say it's the first email, I'll take you at your word, obviously, sir. But I don't recall if I had phone conversations with Mr. David prior to this email, if we met in person prior to this email. But it seems to be it's a year without a renew. Endorsement fee. Must have been, I don't see this stuff.
Let me see if I can kind of orient you here, because I just have a couple of questions with this email. Is it fair to say that as part of your email to Mr. David, you on behalf of B3M were granting Celsius the right to let GNC know that B3M and Celsius were in discussions in an attempt to secure a pledge from GNC that if you could reach a deal, a co-branding deal with Flo Rida, that GNC would be able to stock its stores with that co-branded product? In other words, you were granting Celsius permission to talk to GNC to confirm this.
Yeah, that was a request of Jerry David. Before I did the email, I obviously contacted Mr. Mathis. I said, look, they want to, say that we're in discussions. It works out. They're going to pick it up in 1,800 stores. It's good for everybody.
Because at this point, there wasn't a deal between B3M, Strong Arm, and Celsius, but Mr. Celsius wanted to know that they were authorized to approach GNC to see if a deal could be made.
Yeah, in good faith, we liked them. In good faith, we said, okay, you could explore it.
And then let's go to the next page. And the next page has a listing of, and this is what you put together on behalf of B3M, correct? These are let's call this, is this the initial ask from B3M?
Again, I don't recall exactly. I believe it was a combination of just after Jerry and I had spoken and met, deliverables that were discussed, that were on the table, potential deliverables. As I stated earlier, DRTV spot. I don't know if Jerry asked for that or I suggested it, because they have a pretty powerful direct response TV personality on their board.
But these are your words. This is your email.
Yeah, no, absolutely. I crafted.
And so let's focus on the first part. It says here, deal structure and deliverables, and then in parenthetical, you said, based upon our being comfortable with the company's cap structure and becoming a fully reporting company in a reasonable time frame, and then these are the terms. So this is consistent with your testimony that you had some concerns about the size of the company and its capitalization and things of that sort, correct?
Correct, because again, they were on the pink sheets.
And the idea being that there was going to be, instead of a 7-figure cash payment up front, there was going to be stock in lieu of that, right?
Yes, and Jerry, to put me in a comfort zone, I'll spell every bit of the time on the long version of the story. The short version is that before Jerry's watch, Bill Momo had the company on NASDAQ trading fairly high. Don't recall what fairly high was in those days. And then they kind of messed up all the marketing and they chose the wrong people. But he had me convinced, hey, we made it there before. Okay, with bad marketing, imagine what the stock's going to be worth with good marketing and flow.
So let's talk about some of these, just a couple of these provisions, and then we'll move on. So, number one, 2-year licensing with auto renew. Is that acceptable to Celsius?
I don't know. Is it? I mean, I'm not being facetious, but you're probably more familiar with our contracts than I am at this point. I don't know. Is that clause in the 14?
No, it's not, but it's okay. Just, if you don't know the answer, that's okay. You can say it. You don't know the answer.
I don't know the answer.
All right. And then there was, and again, this is D3M asking Celsius, there was going to be a $200,000 guarantee against royalty with $100,000 up front, and then there was going to be the $250,000 later.
Correct.
Is that correct? All right.
Yeah.
And then there was the $100,000 endorsement fee paid upon signing, plus an agreed upon percentage of equity. Equity is stock, right? Shares.
Correct.
All right. And options in the company on a non-diluted basis. We don't need to deal with that for now. So in addition to the $200,000 royalty guarantee, there's going to be an endorsement fee, cash, right?
Correct.
And that was like an endorsement fee for the brand ambassadorship and all the promotion of product and things of that sort, right?
It was part of there's royalties and then there's fees. Okay, on licensing. And this was fairly low, but it was it looks like we're still in the negotiation phase. I'm starting to recall because they did not honor. I didn't get what was important to me for my client and for my partners was the non-dilutive stock options, which never happened. So a lot of what we're looking at here was still initial negotiations, and we ended up going back and forth.
Fair enough. These are all initial negotiations, right?
Correct.
And then, in return for all of that, the company would have access to Flo's images, displays, his intellectual property, basically, correct?
Yes, and then we had to create, or Flo had to create unique content because, yes, he's already in health and healthy lifestyle. At that point, he'd already been on the cover of Muscle and Fitness, but they wanted him to get in like even greater shape. So he hired another trainer and worked out gruelingly and did a photo shoot specifically for Celsius, video assets specifically for Celsius, and that's above and beyond what you traditionally give a client when you sign a deal. So they're called style guides. So if you get a Spider-Man license from Marvel for T-shirts and whatnot, they'll send you something called the style guide. Like, here's all the stock images that you could use, and that's that. So we gave them our stock images, okay, that we would give any other client, but Flo had to provide, and we needed to provide, or D3M needed to provide to Celsius. We had to get it from Flo, all the unique content that was Celsius specific. We couldn't reuse it for other purposes.
Okay. And then number 6, and this is from you, going to Celsius, Mr. David, personal appearances at national retail store locations to help launch the co-branded line, and then travel and lodging will be paid by Celsius via appearance fees waived. So the idea being that Strong Arm Flo Rida would not charge for the appearance, but their out-of-pocket expenses would be covered, correct?
Yes, and again, this is not the final, because that was not approved by my client.
Right. But this is conceptually something that you're putting out there for Celsius to consider.
Your
Yes,
Honor.
like any other negotiation, starting point.
All right, so next.
Your Honor, I object to this line of questioning because it doesn't pertain to any ambiguity in the contract, anything at issue in the lawsuit.
All right, objections overall, but let's move on.
All right, let's go to Mr. Davis' response. Let's go to Thursday, February 20th, 11:31 a.m.
Well, I think this is what's not in evidence. The court just ruled what the witness has written is in evidence, and
God, this isn't, I'm confirming
All
the whole email.
Hang on. So this is,
Yeah, and it's being shown to the jury that this is not
all right.
the proper procedure.
Your Honor,
All right,
Exhibit 6
hang
has
on.
been entered.
And it was subject to potential redactions. Are you objecting to that part there?
This is an
Hang
email
on. Are you
Yeah.
objecting to this part?
Yes, because it's, I can't even read it, and it was supposed to be done this morning.
All right, I'm going to overrule the objection. This is a response to the,
Your Honor, he has a full copy
I
of this
understand.
illustrated, and this is an email from Mr. David.
ask your question. All
But
right.
can I just ask, if he's going to show something that's not in evidence to the jury, that I see it first?
He knows. All right, but this is in
Yes, he
evidence
knows.
as part of the exhibit. That's in evidence. I'm allowing it. You may
Your Honor,
continue.
Just so that we're clear, this is Defense Exhibit 6. I'm going to ask questions on every one of the emails here except the first email. Because that was just a forwarding.
All right. Let me see the exhibit. Let's see the full exhibit.
That's the exhibit, the judge must have seen.
Your Honor, I have a hard copy.
I give it to you.
Thank you.
So,
All right.
here's the.
Let's do this. All right, these are emails from this witness who is your partner, your party, your party, and the other emails are from Mr. David back, and it's just back and forth. And so I'm going to allow it all in. Our objection's overruled. The entire Defense Exhibit 6 is in evidence.
So, first of all, let's look at the February 20, 2014 response by Mr. David to you at 11:31 a.m. And I just want to confirm that Mr. David's response was, well, let's just look at it. It says, responded to the guarantee, first paragraph, the guarantee against royalty will be modified to $50,000 up front and $50,000 at 6 months, 12 months, and 18 months. So he was changing the upfront money that you had requested for the royalty payment, right?
Apparently.
Last sentence, first paragraph.
No, I see. It's been quite some time. Yes.
But that was the position that he took at that moment, Mr. David.
Yes, it's like he was countering.
And then with respect to the stock, he says they were prepared to provide 500,000 shares in the following fashion: 250,000 shares up front, and 250,000 shares when revenues on the co-branded product reach $1 million. You see that there?
I do.
All right. So, wasn't it your understanding that what Mr. David was telling you, that Celsius would grant 250,000 shares when revenues on the co-branded product reach $1 million, right?
Correct.
And what was being discussed at the time, that what was being considered a co-branded product, was a co-branded powdered product that had Flo Rida's image, likeness, or logo on it, right?
Not necessarily. Co-branding in our space, it'd go through, yes, the indicia or the likeness on there, or or the celebrity is endorsing it. Okay, that could also be, when it gets to a point where a celebrity becomes synonymous, like Shaq and the Heat stuff, his face isn't on the product, but you see him, you think of the Heat, that's first comes to most people's mind. So the intent was, when we would, that's why we gave them exclusivity. And Flo went above and beyond so much because the Celsius, the drink actually became known as Flo Rida's drink to consumers and other celebrities and whatnot. So to answer your question, sir, it was not limited to just the products with indicia.
All right, so I'm a little confused, Mr. Gold, because let's go back to your February 7 email, and let's go to the second page of that email, Scott, please. And in that email, under licensing and endorsement, this is your writing, Mr. David, you wrote in the parenthetical, co-branded line of Flo Rida / Celsius powders. You see that there?
Which number was there?
Looking at the line that says licensing / endorsement.
Oh, the header.
Yes.
Okay, co-branded line of Celsius powders.
And also number 8, you reference adding Celsius Flo Rida powder into Flo Rida performance record. You wrote that as well, right?
Correct.
So the concept here, at least that was being discussed between you and Mr. David, isn't this correct? That it was going to be a new product, co-branded, that had Celsius and Flo Rida on it, and it was going to be a powder. Isn't that right?
At that time, but it evolved
I
after
see.
the contract.
All right, so it evolved. All right, we're going to get to that. All right, let's go to your response to Mr. Gold. And like I said, I think there were a lot of back and forth on February 20th. Let's look at your response, February 20 at 1:50. And is it fair to say that you rejected Mr. David's proposal because you said, quote, your structure is not acceptable in both cash component and equity participation, right?
Yeah, apparently it was rejected by Flo and Freezy and Ms. Mathis.
You wanted more cash and you wanted more equity, right?
Yes, as I stated earlier, it should have been a 7-figure deal.
Right? And then Mr. David responded to you, same day, 4:54 p.m.
I'm sorry, can you pull that up again?
Sure.
Apologize.
Absolutely.
I mean, I haven't seen these
Sorry,
things
do
in years and years.
Take your time. You need to read the whole email.
If you scroll, there's some bullet points.
Scroll down for me, please.
Okay, we believe that both companies agreed to such nominal and cash again respectfully. Decline your proposal. Oh, am I allowed to read this out loud?
No, just read it to yourself.
Okay. Yes, we had a problem with it because they weren't trading on the NASDAQ and it wasn't liquid and the shares were, you couldn't do anything with the shares.
You were concerned that if you got 250,000 shares, you wouldn't be able to move it because they weren't trading on the exchange.
Even a move is 22 cents.
All right, so now let's go to Mr. David's response to you. And he's called this a counter. Was this a counter to what you said?
Is this in chronological order?
Yes,
We
sir.
had so many emails.
I represent you that this is in chronological order.
I believe. Millions of dollars. Hang on for thought. Okay.
Okay?
Yeah.
So, Mr. David, for 1,000 shares up front, right?
Hmm?
Yes, you have to answer.
I apologize. Yes.
Okay. Then another 250,000 shares when $1 million in revenue is achieved, and it doesn't specify what kind of, it just says revenue, right?
Correct.
All right. The next one is 500,000 shares when 690,000 units are sold from all channels of distribution. And in the parenthetical, he says that equates to 1% of Flo's followers ordering 3 times on average. You see that there?
I see it, and I don't know if that made it to the final loan form contract.
Okay. But there was a component in the long form contract where there was going to be a benchmark that if there were sales of 690,000 units, an additional $500,000 shares would be issued to.
No, I agree with you absolutely. That was there. What I was saying is in the parentheses that you just read out loud that equates to 1% of Flo's followers ordering 3 times on average. I don't believe we approved that to go into the final contract.
Fair
My recollection, because that's putting the onus on us selling the product for them.
Fair enough. And there was, and then we talked about the 100,000 up front, and then some more money for the road. And then last but not least, is your response email, February 21 at 11:20 a.m. to Mr. David. And is it fair to say you basically
Could you enlarge that, please?
You were telling Mr. David, I think we can live with this. This is a structure that we can sell to Flo Rida and Straw, right?
Yes.
And then, as a follow-up to that, you then basically told Mr. David, you're going to have an attorney put together an MOU. What's an MOU?
Memo of
So
understanding.
you're going to have an attorney draft an MOU that will be used as the guide for the definitive agreement.
Yeah. Short form, we agree to this. Without all the legal, the jargon.
And then let's just go through quickly this. I believe this is already evidence, plaintiff's exhibit. The memo of understanding.
If it's in evidence, I have no objection. If
It's
it's
not
not in
from our
evidence,
side.
then I object to
So
showing.
maybe you put it in.
This
Wait,
is
wait.
your
Wait.
document.
Okay. Hold on.
I know, but sometimes.
Okay, Christina, I'm sorry. If it's not in evidence, it shouldn't be shown to the jury.
No problem. And we'll go through it. You want a copy? What do you want?
I don't see it on either of the lists that I have.
All right, what's the number again?
41 plaintiffs.
Plaintiff's Exhibit 41. Is there one there or not? I can't see. No?
Sorry. Thank you very much.
All right, if I could have a moment, please.
Okay.
I'm going to try to get these documents so that plaintiff's counsel can review them at the same time.
All right, do you have a ways to go?
Oh, yes.
All right. You're going to have to let your next witness know. So that's going to push everything else back.
I understand.
You understand? Okay. So are you putting everything together? Or?
I'm trying just to get a copy so I can show it to Mr.
Why don't we do this over lunch?
Okay.
And then
I'll
if
show
there's any
this now.
additional questions now for about 5 minutes, and we're going to break in about 5 minutes. So.
So let me ask these initial questions if I can show it.
So, Your Honor, this is a 5-page document which I would like to read before I respond.
Are there any other areas to go into, or?
I can go past this and come back to this. Your Honor, just so we're aware, they published this same exact document during the clip of the video they played yesterday.
We'll address this later outside the presence of the jury.
So, Mr. Gold, this was the memorandum of understanding that you had a lawyer prepare to send to Jerry David at Celsius to set forth the general terms of what you believe you had an agreement. D3M had an agreement with Celsius on the endorsement deal with Flo Rida.
Yeah, it's not fully executed, but it appears to be the MU. I don't know if it was the final one or not.
This came from you, right?
Excuse me?
This document came from you.
I don't know. I just see that. That's actually from my wife's signature line is blank. So.
But it has, the letterhead is D3M.
No, it's a D3M document. I just don't know if it's the final.
Right. And so I just want to highlight in the second paragraph of this document, the last sentence, that for purposes of this MOU, the parties intend to develop and co-brand a health energy supplement powder using the intellectual property, and then it's defined as the product. You see that there?
Yes, I do.
So pretty much the entire purpose of whatever definitive agreement circulate or gravitate around the concept
What's happening? So you're acknowledging. Oh, it's on the MOU. Yeah, obviously I recall this. On the, to answer your question, in the MOU, yes, but in what we call the definitive agreement, the final contract, we had changed a little bit of language, I believe, because it wasn't, Jerry was wrestling with, or Celsius couldn't give me definitive what we're doing, how they're going to do it. So we ended up, I think, simply just putting the word "or" as. I mean, it's you see it. I forget the exact verbiage, but I remember distinctly. We didn't want to lock ourselves to this, and he just agreed. He just said, "Look, we'll put the word "or" as," and I apologize, but it'll come up.
So let's. I want to follow up with that what you said about the pricing. So let's pull up. This is an evidence. Everybody knows this is an evidence. It's Plaintiff's Exhibit 1, which is the endorsement agreement of March of 2014. Mr. Gold, this document is already into evidence, and I just wanted to highlight or at least zero in on the third whereas clause in this document. And in this third whereas clause, we just want to be clear that at the end of the day, that concept that the product will be priced at retail between $19.95 and $39.95, or as appropriate for channels of distribution.
There we go. Or
That ended up in the definitive agreement, correct?
correct. So the "or" was pivotal because, as I said, the product line evolved.
Sure.
You know.
And again, the document, so we're clear, we're all on the same page, in the second whereas clause, the definitive agreement of March of 2014 identifies or has a term called core products, right?
Could you repeat that? I apologize.
That there's a definition in this document of what is core products.
It was core products. Okay.
And this is a definition that we agreed to by D3M and by Celsius, correct?
Yes.
All right. And so core products are that the company produces a range of products consisting of nutritional, energy, beverage, dietary, supplement, and sports enhancement beverages. Products. That's what it says, right? Distinguished from the term products, right? Which is in the next paragraph. Of its core products in a powdered form and co-branded using endorsement. Such new products are referred to as the products.
Correct.
So this is something different than the core problems, right?
Well, it was,
No,
It-
just answer that question first, and then you can explain. This is going to be something
physically different. It would be the same exact formula with the 6 clinical proven studies, which was one of the things that was a big decision maker for Flo, to make sure it was healthy. And it wasn't going to be another Red Bull or one of those, play games for 72 hours.
Let me ask, is this a good point to break?
This is actually a good point.
Okay. Manager, we're going to go ahead and break for lunch. I'm going to bring you back 1:15. So you have an hour and a half for lunch. During the break, do not discuss the case, rather discuss the presence. Do not go and investigate. See you back here ready to go 1:15.
to the second page, paragraph 1, term. Let me know when you're there, Mr. Hall.
Okay.
Yes, I'm here.
Okay, so just so that we're clear, the term of this agreement was for 2 years, starting the effective date, which was, this was March 9, 2014, and it ended, or was set to expire on March 6, 2016, right?
Correct.
Unless mutually extended by the parties in writing, correct?
Correct.
So in other words, if there was no further writing, this deal was going to end, and everybody goes their separate ways, right?
Yeah, if we didn't mutually agree to renew.
Exactly. So if there was no extension, everybody goes their separate ways.
Correct.
We tried, we failed, and we moved on, right?
Correct.
Let's go to, just want to understand a little bit about what Celsius could do with Mr. Flo Rida's image, likeness, and things of that sort. Let's go to page 7, paragraph 6.
I'm here.
And I want to call your attention to subparagraph C. Tell me when you're there.
I'm here.
All right. So, paragraph C, would you agree with me that paragraph C allowed Celsius to advertise, promote, endorse, and publicize the products and the company's business worldwide in any media selected by the company, including, and then they list the media. You agree with me on that?
That's what paragraph C says.
All right. So products, as we know, we've already talked about it, are the co-branded powdered products, correct?
The co-branded and their RTDs.
Well, it doesn't say that, does it?
Well, it says company's products.
Well, products. Let's go back to the first page. I just want to make sure that we're not reading something into the document. Products, there's no mention of RTDs in the definition of products, right? In the first page? Third whereas clause?
Can you pull it up again, please?
Sure.
Okay, come in. That is what that paragraph says. My understanding and the intent and what we moved forward on was he was the worldwide brand ambassador for their existing RTDs, and then we were going to work together jointly on the powdered products and how to market them.
So let's break that down. So first of all, let's be clear. You agree with me that an RTD is not a powdered product, right?
It's the canned drink.
It's a liquid drink, right?
Correct.
And to the extent that Celsius wanted to market and use Flo Rida's brand to market and promote the RTDs, it could do so under the terms of this agreement, correct?
Correct. But I also believe we had somewhere in this long form as we had final approval and Flo had final approval, meaning they couldn't just go out.
Right. Understood. Now, obviously, they couldn't put something inappropriate, something that would be inconsistent with his values and beliefs and things like that. That's understood.
Rose brand or anything. Correct.
That's understood. All right. And so, again, just so we're 100% clear, the ability of the company to use Flo Rida's likeness, image, his intellectual property was not limited to just the co-branded powdered product, correct?
Correct. With approvals.
So, Mr. Gold, you're familiar with an individual by the name of Johnny Nunez, right?
Yes.
And could you please tell the jury who Johnny Nunez is?
Johnny Nunez is a celebrity photographer. He is most well known for, I guess, the hip hop space, but not limited to. Would you like me to elaborate on our relationship?
Yeah, I'd like you to elaborate. I mean, let me cut to the chase. Didn't D3M, Celsius, and Johnny Nunez enter into an agreement date after the 2014 agreement with Flo Rida?
It was a little while after. Johnny's business model was he'd be on all the A-list parties and whatnot, and he used to get to go as himself and as a photographer, take his pictures. The celebrities would give him releases, certain ones, and then he had a relationship with something called Getty and Wire Images. He'd post them, and that's how he made his money. You could actually go on Getty Images if anybody wants to spend $400 and get a picture of me and Flo. It's on there. But that was his model, and we were introduced, through friends in common. It's a very small knit group, and we would hire Johnny. Flo was aware of him. We'd fly him out to pay for his hotel, whatever, to be the photographer on certain Flo Rida events. He was a photographer that we recommended to Celsius to hire for the still photographs for the assets. Ultimately, the relationship got stronger, and we ended up signing a contract with him because we believed he was a celebrity, a potential celebrity in his own right. There was things that could be done.
Mr. Gold, let me show you a copy of the document. Can you identify the document? Is that the contract that D3M and Celsius entered into with Johnny Nunez?
Yeah, D3, this is post. We did an agreement. We did an endorsement licensing agreement with Johnny first. So Johnny went from being like a 1099 work for hire person for us to kind of a hybrid where we'd hire him to do jobs, and we also had the right to represent him. Quite frankly, we were trying to do a coffee table look.
All right. But this is the contract D3M entered with Mr. Nunez and Celsius, correct?
It was through D3M, yeah, correct.
And that's your wife's signature on the contract, correct, as representative of D3M?
Yes.
All right. Your Honor, I'd like to move into evidence, defense exhibit 11.
I have no objection to the defense using it with the witness, but it's still on the plaintiff's case, so I do object to going into evidence.
Your Honor, I'm trying to avoid.
Hang on,
I can call back Mr. Gold.
I understand. That's the only objection?
Yeah, I'm not suggesting that he would have to call back Mr. Gold.
Yeah.
Just
All right, that's not my question. That's your only objection? Objections
Yes.
overall. The court has the discretion to allow. So, defense exhibit 11 is in evidence.
Mr. Gold, I just want to direct you to one thing on this document. So let's go to the second page, and I want you to focus in on paragraph 1, term. Let me know when you're there.
Okay.
All right. So in this document, it had a term very similar to the 2014 agreement between Celsius and D3M and Strong, correct?
Well, this seems to be 1 year, right?
It's a 1-year deal, right? And it's going to continue. So the document, the execution date on this document was, let's look at the beginning. It's effective as of July 1, 2014. Yeah, the first page.
Yes.
And then the second page, it says here that this term shall continue until July 31, 2015, unless mutually extended by the parties in writing. You see that there?
It is 1 year. The Celsius agreement was 2.
All right, but in other words, there was a term. There was a length of time in which this document was going to be active, correct?
Yes.
And then it could be extended in writing, correct? That term.
Yes.
All right. So, was this agreement extended?
It was my recollection. I honestly, I forget. One party, I think Jerry, had an email that said he'd extend it for a year, and I believe Johnny didn't want to continue on it. I don't recall.
In fact,
100%.
Isn't it true that the document was in fact extended by 1 year in writing?
I I don't recall if it was fully executed. I know there was an email from Jerry, because I had asked him to extend it.
Your Honor, may I vote?
Yes.
Showing you what we've pre-marked as Defendant Exhibit 12, Mr. Gold, and does that refresh your recollection that the Johnny Nunez agreement that we just saw, Exhibit 11, was extended for 1 year?
I don't recall seeing this, and again, it's my wife's signature, but
That is your wife's signature.
yes, but I
And
don't
at the
remember.
time, she was the representative of D3M, right?
She was the sole managing member and the CEO.
She was fully authorized to act on behalf of D3M.
Yes, she was our CEO.
And so, Your Honor, I'd like to go ahead and admit into evidence Exhibit 12, Defendant Exhibit 12.
No objection.
All right, Defense Exhibit 12 is in evidence.
So this is an extension in writing, right, Mr. Gold?
Yes,
Pretty simple. It's one page, extended 1 year, right?
yes.
But you knew how to do this.
Excuse me?
You knew how to do this.
I knew how to do what?
Extend an agreement in writing with an addendum, right?
I've never done any legal paperwork. I know that there are extensions.
And this is one of the ways to do it.
Yes, this is one of the ways that attorneys will do it.
And it makes it clear that, it's being very clear that the agreement, the earlier agreement that was signed in 2015 is being extended 1 year. So there's no doubt exactly what the parties are intending. Isn't that right?
Again, okay, my recollection is Johnny didn't accept it. And if you see on the 14 document you gave me, there's similar to what Flo has signed with us, is the inducement guarantee stating that we have the rights to do this. I don't know if it exists, but I don't recall ever seeing the inducement, and I don't recall ever seeing this. I know it exists, obviously, I'm looking at it. But without the inducement from the client, it doesn't empower, from my understanding, an extension.
But clearly, Celsius and D3M were trying to extend that agreement for 1 year under that document, correct?
As I stated earlier, my recollection was we're trying to get Jerry to extend it, and I believe Johnny didn't want to continue,
Okay.
or vice versa. I just remember there was one party that didn't want to continue.
So,
And this was my wife's relationship, quite frankly. She kind of spearheaded things with Johnny.
So let's switch gears now. Let's talk about a promotional event that took place between Flo Rida and a NASCAR race car driver named Blake Cook. You recall that promotional event?
Which one?
The NASCAR race, the rapper versus racer event.
Yeah, I recall that, and that was after there was a previous one where Flo did the flag and whatnot. There's a little more backstory to the NASCAR, but there was a relationship that we had established with NASCAR on behalf of Flo Rida. Went very, very well. And they asked him, the next was to go present the awards to Tony Stewart and whatnot, all the big drivers in Vegas. And then Rapper versus Racer came to be, which was an internal project.
The racer's father is a gentleman by the name of Mark Cook, correct?
Correct.
Right. And you recall that Mr. Cook, Mark Cook, wanted to make a charitable contribution to Flo Rida's Urban Flag Football League, correct?
It was actually the contribution that he made through, actually, I don't recall if he wrote the check to D3M and it flowed through, but it was, I believe, the 501c3 is Big Dreams for Kids, which under it, Flo not only has the Florida Youth Football League with 10,000 children, there's Gospel Explosion, there's Kid Fest that we always supported on an annual basis where Flo does all those
Ultimately, the
things.
contribution was intended for a charitable organization that had been created by Flo Rida, correct?
I don't recall. I know one of the checks, there were 2 checks that he gave.
I'm not concerned about how many checks he gave. I'm just saying that the contribution was intended, whether it was 1 check or 2 checks, to that organization.
Yeah, to get to Flo.
All right. And I believe the contribution amount was $50,000, right?
I don't recall the amount, but if you say so.
Isn't it true that as part of whatever the contribution amount that Mr. Cook wanted to make, D3M took $18,000 of that contribution?
That I have no knowledge of. I
You
didn't.
have no knowledge?
No, I did not handle. I was never on any bank accounts. Didn't handle any of that.
I see.
I know I knew of funds, obviously, in sales when they were due, and I would contact. There was a period of time that my wife had the bank accounts early on, and then we transferred everything to the corporate offices in New York. So we'd instruct, they would notify us if a wire came in or a check came in, and then we'd have the turnaround. I would call Mr. Mathis, and he would instruct me, which of the strong arm accounts to go to, or if it had to do with one of the charitable events that went to either a trust or whatnot.
So you don't have any specific memory of taking out $18,000, D3M taking out $18,000 of the $50,000 contribution made by Mr. Cook?
I don't know. We did a lot with Mark in those days.
I know, but I'm asking you, do you recall?
I do not recall that specifically.
And do you recall whether Mr. Mathis and Flo Rida became angry at D3M because they took out $18,000 of that charitable contribution that was intended for Mr. Flo Rida's charitable organization?
Never happened.
Okay. Now, let me see if I understand your testimony today, Mr. Gold. You're not here to testify as to the damages that D3M is claiming in this case, correct?
I don't understand the question, quite frankly.
Sure. Let me put it this way. Isn't it true that the person that's going to be testifying as to the amount of damages that D3M is claiming in this case is going to be your forensic accountant?
Your Honor, that calls for a legal conclusion. That's not.
Sustained recurrence.
I mean, sitting here today, you don't have a number that D3M is claiming.
I do not, because I'm not familiar with the laws, quite frankly.
So you don't have a number that you're going to tell the jury?
A dollar
what
amount,
damages.
myself?
Yes.
No, I personally do not. I rely on.
Oh,
I just know the share amounts and what market value is.
you don't know what the number is.
I know we're looking jointly to get what is owed, which is the equivalent of 750,000 shares of stock. I don't know how the law arrives at the market price, quite frankly, if it's a cash award, or if we get the stock and everybody Flo decides what he wants to do with the 75%. My partners, I decide what we want to do with that 25%. Do I want to throw it in trust with my daughter? I honestly don't know. I just know that we're owed.
So let's go ahead and call up Defense 323. Scott, please. Yes, it is. Let me give you a copy.
What's the number?
323.
You can give it to John.
All right, Mr. Gold, this document is already in evidence. This is the Defense Exhibit 323. And now I'm actually moving ahead to 2016. And before I ask some questions about these documents, this email, excuse me. So we had reviewed the term of the 2014 agreement, and it stated that the term was for 2 years, and it was set to expire, I believe, March 9th, 2016, correct?
Yes.
All right. And so this email is about a month before the expiration of the 2014 agreement, correct?
Correct.
Right. So you were beginning the process with respect to the 2014 agreement on the verge of being, on the verge of expiring, you were beginning the process of discussing with Mr. David, right, according to this email, of you would like to see similar contract as is currently in place with increased cash and stock positions. Correct?
Yeah, we're talking about the renewal.
Right. And then you said you were going to, deliverables can be amended to fit Celsius' desired marketing direction, so there were going to be new deliverables contemplated, correct?
Correct. As Vanessa Walker, I believe at that time was, I don't know, the second or third chief marketing officer they had gone through. They had a lot of different directions, so she had new ideas, and Flo was open to exploring the new directions.
And then you ended up by saying kindly advise on when to expect a new proposal. You were expecting a new proposal from Celsius?
Just on the additional deliverables that Vanessa was discussing.
Wasn't there going to be some changes on the financial terms in the new agreement?
On the financial terms, yeah, I mean, Flo's, since we had started that agreement, I mean, obviously Flo knows better than I, but he had, I don't know, 3 or 4, 2 quadruple platinums, another couple of platinums, other awards and whatnot. His brand had increased in value, and as such, since Celsius was not in a position when we did the 14 contract to handle a bigger cash payout, and we knew firsthand that, they were a lot more liquid by this time, my instructions from Strong Arm were, it's a little more upfront.
All right. And so, again, you're starting the process again of negotiating. So let's go ahead and go to Exhibit 326, defendants, which is already admitted. So your primary point of contact in the negotiation was Vanessa Walker of Celsius, correct?
No.
No?
No.
It was still Gary David?
No.
Who was it?
They brought in, now I'm starting to recall, I apologize, but it's some time ago. So we had the meeting. That did happen. It was positive. Some of these emails went back and forth. And then there was kind of radio silence. And as I stated earlier, I was talking to Flo and Mr. Prince and Mr. Mathis, and they're like, look, either way, just get an answer, because there was what's called the cooling period, non-compete. So I, called Jerry finally. I said, look, do you want to renew? Fine. If you don't want to renew, okay. That's when he called me back, as I stated earlier. He said, we want to renew. We'll be in touch. And at that point, they gave me Howard Wishner to do all the extended deliverables on the renewal of the 14 contract.
But in the end, the actual communications that you had in your email, as reflected, for example, in your email of March 7, 2016, was between you and Ms. Walker, correct?
March 7th.
I'm looking at the 838 email.
Yeah, that's March 7th. Okay, but we didn't start. And I don't recall the dates that Howard and I had the 3 weeks. I don't know if it was prior to this or after. I don't know if your opinion has that.
But the point is that you were going over different financial terms for a new agreement that was going to be executed because the other agreement was expired, correct?
No, it was a renewal of the old agreement, but Flo's value had increased. Okay, and plus we believe we had proven ourselves way above and beyond, okay, and that everybody all around deserved additional compensation for the renewal. It was an extension of deliverables on a renewal of what was already in place. He was worth more, and we, quite frankly, worked very hard for a couple of years. If you break it down, it's going to come down to like minimum wage.
So let's talk about so we had, in the end, very similar to the first agreement, you went ahead and entered into a summary of binding terms or a memorandum of understanding. Let's look at Defendant's Exhibit 24, which is, hold on a second. It's already moved into others, okay. Go ahead. Go ahead. So this is the MOU for the 2016, which ultimately became the 2016 agreement, correct?
If you could scroll down a little bit. Closing March 31st.
I'm sorry, Your Honor, my whole system went down. So I've had issues with the internet and causing things to freeze and frozen. Can you do starting files?
Thank you.
All right, and just so we're clear, this is which exhibit?
This is Defendant Exhibit 24.
All right.
Ready, Your Honor?
Yes, you may proceed.
Thank you. So, Mr. Gold, in Defendant's Exhibit 24, you'll agree with me that there's no mention in this document of the 2014 agreement.
There wouldn't be. It was to renewal.
Let me go through these questions and make it explain. So there's no mention. Number two, there's no mention in this document about the benchmarks that were identified in the 2014 agreement, the two stock benchmarks, $1 million gross revenue and the 690,000 units. Right?
Again, it was.
Just answer that question. There's no mention of that in this document.
There's no mention of it in the document because it carried over from
I
the 14 contract.
And your lawyer will be able to ask you questions about that, but just want to make sure that there's no mention. All right.
The screen went blank. I don't know if it's supposed to.
That's fine.
Aaron, 1 second, please. Just make sure.
While you were negotiating what was to become the 2016 agreement, isn't it true, Mr. Gold, that you actually provided some language with respect to the royalty provision in the 2016 agreement?
I do not recall. If you could show me something to refresh my recollection.
I'm sorry?
I said I do not recall. If you could show me the document to refresh my recollection.
Does this document assist you in refreshing your recollection with regard to whether you provided the language for the royalty provision in the 2016 agreement?
You talking about 5.3?
Correct.
My recollection is that was not my language. That was provided by Celsius, is the best of my recollection.
So, but this is an email from you to H-Wish 315. Who's H-Wish 315?
Okay. The gentleman, Howard Wishner.
Okay,
that
so
we
this is the
discussed.
gentleman you talked
He was,
about.
yeah, he was the chief. He was consulted, brought in just to negotiate the extended deliverables on the renewal of the 14 contract to the 16, because he was an expert, as told to us, and from my understanding, actually Vanessa Walker used to work for him sometime in the past. They brought him specifically in for his marketing expertise to work with me directly, because I never really worked with Vanessa directly. I think I met her twice. On the extended deliverables, which I agreed, and Flo agreed, that when Celsius wanted to renew, Jerry wanted some extended deliverables. And we agreed to that. And then Howard and I worked for those 3 weeks that I discussed. And I believe Jerry went out of town, he was on vacation. Vanessa wasn't part of that. Now, did Jerry have to sign off on it ultimately? Yes.
So ultimately, if I understand the concept of what was changing from the 2014 to the 2016 agreement, is the parties were moving away from the benchmarks related to either revenue, recognition, or the amount, a certain amount of revenue, or a certain amount of unit sales, and now moving more towards completely a royalties type compensation feature, correct?
Incorrect.
All right. Please explain why that's incorrect.
Okay. It was understood that because it was a renewal, that the bonuses and the benchmarks stayed the same, where there was going to be some added deliverables. One of the things that had changed, I believe my recollection is 100% accurate, at the meeting at Strong Arm in the conference room that was referenced, I guess, in the previous thing that you had on. Flo was present, Vanessa was present, Mr. Mathis was present, I was present, and I apologize, I'll try to shorten it. Jerry agreed to move forward, and then they offered Flo in it because we were going to extend the courtesy of expanding the deliverables. All of a sudden, they offered him his own flavor of the RTDs.
Right,
Okay,
so
that's what I believe this is referencing. So as an addition to, we got to keep everything we had in 14 because this was a renewal. We were giving them more, a lot more.
So let's go to the plaintiff's exhibit 2, which is an evidence, which is the 2016 agreement. And in this agreement, just so that we're on the same page, there's no mention in this agreement about the prior benchmarks or the issuance of stock from the 2014 agreement.
Correct.
All right. And in addition, the compensation that is contemplated in this agreement, if we go to paragraph 5.3, actually let's start with 5.1. Let's go through this. So you had various compensation provisions in this agreement. The first one was you had an endorsement fee in which the company Celsius was going to issue 250,000 distributed shares, correct?
Correct.
And these were going to be delivered or issued pursuant to the A and B in the percentages set forth in A and B, correct?
Correct.
Some would go to D3M and some would go to Flo Rida or Sean, correct?
Correct.
All right. And then with regard to, there was going to be a guaranteed royalty, right?
Yes, there's always a guaranteed royalty.
And that's $500,000.
That was the additional funds.
So that was the additional, that was new, that was more money up front for the guaranteed royalty, correct?
Correct.
All right. And then the last thing, and then it was the payment of the guaranteed royalty was over time. But the last thing was 5.3, which is the company was going to pay a royalty to D3M as set forth in 5.3, correct?
The sparkling orange drink that I just mentioned.
So that was new. The parties agreed that there was going to be a royalty paid based on the domestic U.S. ready-to-drink sparkling orange that Celsius manufactured, correct?
Yes, in addition to everything else that was renewed from 14.
Well, in addition to the Flo Fusion branded powder sticks sold in the domestic U.S., the royalty was only limited to those two items, correct? That's what it says there, right?
That's what it says. Yes,
Okay.
but this was in addition to.
Oh.
Instead of.
Well, we'll get to that later.
Okay.
So, I'm just focusing on the royalty. All right. Now, there's no mention here in this in 5.3 that these royalties are in perpetuity, right?
No, but it didn't have a term.
Doesn't say, no, that's not my question. The question is, there's nothing here that says these royalties are in perpetuity. There's no language in there that says this is in perpetuity.
Not that I see, no.
Okay. Let's go to 1310. Section 1310, which starts on page, unfortunately it doesn't have page numbers. Did you get this stuff? All right. So 1310 is, the header is entire agreement amendments. You see that?
Yes.
All right. And in particular, I'm interested in the last two sentences in 1310. And it says here, D3M and the company represent that no other agreement, oral or written, exists between them. The provisions of this agreement shall govern the relationship between D3M and company. You see that there?
I see it.
Right. And that was in that document, correct? And you signed this document.
Yes. May I respond?
Nope. Your lawyer will be able to ask you questions.
Okay.
Now, last series of questions. The term of this agreement, actually, just one more thing. The term of this agreement expired, I believe, in October 11, 2018, correct?
Yeah, at the 11th hour, after we were vested in this and committed to allow the renewal and the extra deliverables, all of a sudden they tagged on an extra 6 months that they wanted. So when you prorate out the extra money, it was almost, it diluted it, but we allowed it to move forward.
So when the agreement expired in October 2018, Celsius's ability or right to use the Flo Rida's likeness, etc., expired.
It depends. If the excess inventory is still out there, a whole host of times when you're a licensee, and I hate to keep using Marvel as an example, but if you have a Spider-Man license, you had 5 million T-shirts, and the term ends, but you still have inventory, the licensor still will allow it.
But the point is that they couldn't go out and do a new batch of, for example, a Flo Fusion branded products, and like let's say in 2020 start selling it. That would be in violation of this agreement, correct?
Quite frankly, they would need authorization, obviously, to continue.
They would need authorization.
To continue.
Right. Okay. Now, D3M, after this agreement ended in October 11, 2018, D3M was involved in another legal proceeding in January of 2019, correct?
I know there were two after my wife's passing. There were 2 suits that came to be that actually our partners in New York just dispensed with and took care of it. There was never any proceedings or court case or anything like that. I wasn't involved.
But there was also another separate legal proceeding in federal court that involved only D3M, correct? You don't have to disclose what the nature of it was, just that there was another legal proceeding, correct?
I wasn't present enough as a legal proceeding, quite frankly.
Right, but the legal proceeding was initiated by your partner, David Braha, correct?
I'm not sure he knows what he's talking about. Maybe you can show him.
Yeah, Judge?
Yes.
Just so the court's aware, I redacted the document so that we don't have any issues.
What's
And
this
I'm not-
exhibit number?
And I'm not going to be introducing this in evidence.
Oh, okay.
This is just to refresh his recollection.
I personally have not seen this.
All right. But you are aware that Mr. Braha, and just so that we're clear, Mr. Braha is the co-managing member of D3M, correct?
Correct. We're co-managing members.
And so he was authorized to initiate this proceeding on behalf of D3M as the co-managing member.
He was authorized to move forward on proceedings with I guess, my agreement, and that's our agreement as co-managing members. Not an excuse, but I really don't like discussing it much, but it was very fresh after the loss of my wife, and I took quite the sabbatical. And Mr. Braha was handling a lot of the clerical things and whatnot, and that's just...
And D3M, on behalf, through Mr. Braha, filed a sworn paper in this legal proceeding in which he did not disclose, for example, that D3M had an existing contract with Celsius, correct?
As I just said, I was not involved with any of this, nor did I see anything. Okay, I was in deep mourning with my children, and out of respect, the Brahas just handled the business that was still on the table. There was still Celsius deliverables that were doing whatnot, and I did speak to Mr. Braha on occasion on what to do, on how to handle things, but my heart wasn't in it to go after new business and whatnot. So
Respectfully, Mr.
I haven't seen anything that you're talking about.
I sympathize for your loss, but I need to ask these questions so that we can finish up your testimony.
I understand.
And so the question is very simple. Mr. Braha did not disclose in these documents, in these sworn documents that were filed in this legal proceeding, for example, that D3M was entitled to royalties in perpetuity from Celsius, correct?
I'm not being disrespectful. Okay, I have not seen anything that you're discussing, so I can't tell you whether he did or didn't. I know the Brahas for years, the most honorable people, some of the most honorable people I've ever seen.
So the document before you doesn't assist you or refresh your recollection as to what statements were made by Mr. Braha on behalf of D3M with respect to its assets at the time in January 2019?
No, I mean, he handled the banking. At that point in time, I know receivables were still due from Celsius, until the term had ended. We hadn't, I know factually, had it been me, we hadn't realized at that point that we were misled and, sorry to use a harsh language, but lied to, about the sales of the powder. So, didn't even realize by then.
All right. No further questions.
Any returns?
Yes, sir. Let's see if I can do this. Just have to get the just
There you go. Switch it out there.
All right. So first, we started out on cross-examination, we started out talking about whether you're suing for money or stock. Under the contract, you're owed stock, correct?
Correct.
And if Celsius would issue the stock, how would you feel about that?
I'd be satisfied. We got what we deserve, what we work for, what we're owed.
All right, now let's pull up Plaintiff's Exhibit 1, the contract again, page 20. There was some talk about whether this stock should all go to D3M or not under cross-examination, so I just want to show you paragraph 3 again and ask you to read, I'm sorry, paragraph B. Read that sentence.
Company shares. Company shall issue up to 1 million shares of restricted shares of its common stock as directed by D3M.
Okay, and so let me just stop you there. It doesn't say to D3M, it says as directed by D3M, correct?
Correct.
Now, had you ever gotten, before today's date, have you ever gotten stock issued to D3M and Strong Arm?
Yes, absolutely.
All right, and I think it was on, was it 2 prior occasions?
For the Celsius Steel, yes.
Okay, so, and both of those were different. You directed differently. On one, you directed 65-35 split. Another one, you directed 72.5 and 27.5% split, correct?
Yes, actually the first one, since they were restricted, and again, until they were reporting and the value, we were kind of the custodian. Flo knew we had them in
But they were
safekeeping.
different, right?
They were different, and ultimately we directed, as our agreement was with Flo.
All right, and then so this third one is also different. Just for the last time, tell us what's the split. How are you directing it?
Yes. So on this one, it's going to be 75% to Flo and Strong Arm, and 25% to the D3M members.
Okay. And now we're going to look at a different part of the same contract, page 13. So, you know, we've talked about the clause in the 2016 contract that said no, this is the agreement. And there's all the emails and term sheets and stuff are now superseded. Okay. There's also a clause like that in the 2014 contract, right?
Yes, there is.
Right? And that was, there was no other contract before 2014, right?
Correct.
So do you see this language in every contract you've done?
That's boilerplate language I've seen in every contract. Literally is boilerplate. I don't mean to make light of it by smirking, but you know, it contradicts itself. You know, in 14 it was in there because it's boilerplate. There was no pre-existing contract. You know, the 16. I apologize. I didn't mean to cut you off.
Well, I was just going to say, but in 2014 there were emails. We just went and saw them before the contract. There were term sheets. There was a memorandum of understanding, right?
Correct.
Now you couldn't come in here and say, well, here's the email, here's the term sheet, here's the memorandum of understanding, and sue on that, could you?
Objection, Your Honor, calls for legal conclusion.
Sustained.
The point of as you understand this clause in the contract, whatever you wrote in the term sheet, whatever you wrote in the memorandum of understanding is preliminary. The final language is the contract.
Is a contract.
Okay. And that's why you have language like that.
If I made this clause, the reason I apologize again for I'm not making light of it. For the clause to be in the 16 contract, quite frankly, because incidental is
I'm
because
just talking about 2014. Well, really, with both of them, that's why you have language in here like this. Because of the prior term sheets and things like
yes.
Your Honor, objection. Counsel's making closing argument.
All right, it's leading to sustained. If you want to rephrase? Or
No, thank you, Your Honor. So I'm going to who's Kevin Harrington?
Kevin Harrington, actually I've known him
Your
for
Honor, objection.
years.
This is beyond the scope. There was no mention of Kevin Harrington.
I'm not sure who Kevin Harrington is. So, is this connected?
Yes.
All right. Overall, I'll give a little leeway.
Can I approach the witness?
Yes.
So do not read this, but to the jury, I'm just asking, at this point in the proceeding, are you aware, Kevin Harrington was a board member, correct, of Celsius?
Correct.
And also a shark on the Shark Tank?
Yeah, I know Kevin for years, yes.
Is that a statement that Kevin Harrington made, yes or no?
Yes.
Okay. And I'll give that to the clerk after we break.
What is that number?
It's not, I'm going to hopefully introduce the video of that, but I need to lay the foundation.
Okay, but just so we have a record of it, have you marked it for identification purposes, or?
What is it?
We can do the next one, ID.
Yeah, I'll mark it for plaintiff's ID A, if that's okay with the court.
Okay.
Almost done. All right. Can we bring up defense 11? You talked on cross-examination about a contract with Johnny Nunez and Celsius, correct?
Yes.
And that contract was actually extended. Let's pull up defendants 12. And this was actually a one-paragraph extension, correct?
Yes.
All right, so in the Johnny Nunez extension, were there new demands on Johnny Nunez to do new things, or were they the same as in the original terms?
Again, I was not, my recollection
Okay,
was,
if you don't know, just say I don't know.
my understanding is if both parties agreed, it was the same.
No additional
incentives.
compensation,
No, it was,
right? It wasn't an expansion, it was a simple extension, correct?
it was simple. Yeah, Jerry was dissatisfied with Johnny's performance.
All right. So you were talking about what you call the renewal in 2016. And actually, if you look closely at the dates, the renewal, the 2016 contract is signed, I think, it's like a week later than the original term ends, correct?
Correct.
What was the delay? If you guys had agreed to extend it, why wasn't it signed before the initial term technically would have ended?
Okay. I believe Jerry was away. B, Howard was hired to do his job. He did it well, and it took weeks. Okay. However, I had an understanding with Jerry. We agreed that it would be transparent. It would be seamless to customers, to the public.
So you're working with Howard Wishner, right?
On the expanded deliverables for the renewal.
Jerry was out of town and out of the country, I think.
Yes.
And Vanessa, who actually signed the contract, was, you remember?
She was getting married,
Okay.
yeah. Yes, exactly.
So, a couple of things about, and during that week or so in between, did it end or did
No.
everybody keep doing the same things?
We kept working on schedule, okay? So there were things that I was in charge of, on the sales side of things. And my wife, yes, she was CEO, but she was also very proficient at marketing. So we paired, and we're almost, as I said earlier, we felt like we're all family to a certain extent. So we had a social media person over at Celsius, okay? We had Flo's in-house social media. I apologize, we call her Diva, but Valerie, I forget Diva's legal last name, but we're very, very close, okay? So the protocols were that Celsius would serve up the desired content to my wife. She would work in tandem with Diva, Valerie.
Do you mind if I just cut you off there, because instead of getting into all that,
it all
did
continued.
any of that stop?
No. If anything, we did more. We just did more because we knew we were renewing and business as usual.
Two areas left. Okay, one is a document that you were shown, Defendants 326, which was a bunch of emails between you and Jerry David. And you noticed there was another H. Wish someone on the emails to. Who's that?
That is Howard Wishner from Wishner Associates.
So, we talked about whether Howard Wishner on direct said that this was an expansion and an extension. But after the contract was signed, did Howard Wishner... But Howard Wishner is on behalf of Celsius negotiating the contract, right?
Correct.
And after the contract was signed, the 2016 contract, did Howard Wishner tell you it was an expansion and extension?
Yeah, he said it was a renewal. Agreed everything was in place as far as all the incentives in 14. And his job, as hired as a consultant, was to expand the
I'm
deliverables.
talking about recently. I'm talking about after.
Yes, very recently.
All right, last area of inquiry. They were talking about something that was signed by one of your partners and it didn't list an existing contract with Celsius in 2019. I just want to focus you on that date. It didn't list an existing contract with Celsius in January 2019. The second 2016 contract had already expired by January 2019, correct?
Correct.
Okay, that's all I have. Thank you, Your Honor.
Any recross in those limited areas?
Mr. Gold, isn't it D3M's position that the terms of the 2014 agreement are still operative with regard to the benchmarks?
Yes.
Yeah. And also with regard to the 2016, because you claim that the company's entitled to royalties in perpetuity, correct?
I understood it was entitled to perpetuity. I didn't see the perpetuity in there. And
But is that what you're claiming? Is that what D3M is claiming? That you're entitled to royalties in perpetuity with respect to the Celsius ready-to-go sparkling orange drink? Isn't that right?
to be quite frank with you, I'm more familiar with what wrote on the benchmarks of sales on the stock grants, and I just know we never received any monies on Flo's orange flavor.
Okay, thank you. That's all.
All right, members of the jury, any questions for the witness? Any questions? No? All right, you're excused. All right,
Thank you.
call your next witness.
Your Honor, the plaintiff's call Marcy Poor. Marcy Poor.
Yes.
And this is case full name, spell last for the record.
Marcy Danielle Bour, B-O-U-R.
You may inquire.
Thank you, Your Honor. Ms. Poor,
Yes.
what kind of work do you do?
I'm a forensic accountant and a business appraiser.
How long have you been doing that?
I've been doing specifically this forensic accounting and business valuation full-time since 1995. I actually am a CPA, and I've been doing accounting work since the early 80s.
Sometimes a business, for some reason, needs to be valued, and you can look at financial documents and come to an opinion on the value of a company.
Yes,
But that's not what you did in this case, correct?
correct. That is not what I did in this case.
Sorry. I apologize. Can you say that again?
No, that is not what I did in this case.
Do you hold any professional licenses or certifications?
As I mentioned, I'm a certified public accountant in the state of Florida. I also hold a number of certifications dealing with business valuation, and I'm a certified fraud examiner, and I hold a designation Master Analyst in Financial Forensics.
What committees do you serve on for the Florida Bar?
I am currently the vice chair for the Florida Bar Standing Committee for the unlicensed practice of law.
Even though you're not a lawyer, you're on the Florida Bar Committee?
Yes, I serve as a layperson on that committee, and I've also served as a layperson on grievance committees for the Florida Bar and local unlicensed practice of law committees for the Florida Bar over the past probably about 20 years.
Serving on those committees doesn't give you the ability to offer a legal opinion, in this case to the jury, right?
No, as a matter of fact, I'm very well versed on what I can't say with regard to legal matters because I sit on the unlicensed practice of law committee.
Yeah, I mean, in fact, that's not the job of an accountant. That's not what accountants do. They don't offer legal opinions, correct?
Correct.
So that would never be your job. In this case, that's for the judge and the jury.
That is accurate, and I'd get in trouble if I did so.
All right.
Or I could get in trouble.
What did we ask you to do in this case?
You asked me to review and analyze data provided by Celsius in order to summarize and determine certain amounts.
All right, and how much were you paid to do that?
Well, I get paid. The firm that I was with was paid. I'm no longer with the firm, but the firm I was with was paid based on the time.
I didn't even know that you're not even getting paid today.
Well, no, I am getting paid today. To make it simple, I was with a boutique firm that does forensic accounting through July 31st, and I've been working on this case for a while. So the firm was paid up until July 31st. I'm being compensated directly for the work I've done since August 1st.
Okay.
In this manner.
The total is around.
I think that I can probably look and tell you it was in excess of $100,000, but I don't recall the exact amount. I think.
Well, we're going to have to check that. Okay.
Did I do that, or maybe it isn't? You know what? I apologize. I can actually look at the number. I do bring things. I actually have information. I can give you an accurate answer. And I apologize for guessing.
You know what? Do you mind if I have someone get that and I can show it to you so we can move on?
That's fine.
Okay. So what data and source materials did you review?
I reviewed Excel spreadsheets that were provided, as well as some documents relating to the agreements between the parties. I also reviewed some depositions.
Yeah, so, all right, so I'll get into that in a little bit, but the Excel spreadsheets there was computer data provided by Celsius in raw form that you looked at, correct?
In the form of Excel spreadsheets, yes.
All right, now what about, you didn't say anything about reports from Celsius specifically calculating if certain benchmarks had been met under this contract. Why didn't you review those?
I was not provided with any. To my knowledge, they do not exist.
Same thing for Flow Fusion sales. Was any report provided about the analysis of Flow Fusion sales and royalty payments, anything like that?
No.
Heat sales, same thing?
I'm sorry, which?
Heat, the Celsius heat?
Actually, I don't recall seeing anything specific to Celsius heat in any sort of report. I mean, there may have been a cell that said Celsius heat in some of the Excel forms that I received, but no, I did not receive any heat reports.
Nothing said royalty payments to Flo Rida and a report?
No.
Okay. And so in this case, we're looking at a clause in the contract that involves 690,000 units sold as a benchmark and $1 million in revenue. Well, what is revenue is received? $1 million in revenue received and 690,000 in units sold. Okay. So did you receive a report from Celsius where they analyzed and said, here's how many units, and we met the 690,000 in Flo Rida's contract on this date, or we didn't meet it, or anything like that?
Other than for purposes of the litigation, no. I did not receive any reports that were done over time.
And same thing for the $1 million in revenue? No reports that Celsius did?
No. The same. Nothing other than specifically for the litigation.
All right. Now the raw data that you did get, tell me about that. Were there any issues with, say, accuracy, for lack of a better word?
Yes, there were issues with regard to certain mistakes in the information that was provided, as well as there were minor issues with regard to duplication. There were issues with regard to certain cells not being populated with information.
What is a cell, just for someone like me who doesn't use a spreadsheet?
So a Excel spreadsheet is a blank slate, and it's divided into little boxes, which we call cells, and there's data in that information. So in a particular row or column, there may be, for example, product type. So there would be a list of all the sales, and then each row for each sale would have a column for, in the column for product type, there's a little box, and there's either information there or not.
All right, so I'm just going to list for the record and verify with you that the raw data that you looked at is in evidence. It's plaintiff's 147. That was a spreadsheet of sales. Plaintiff's 148, which is listed as CEL 130,785 when it was produced by Celsius, and plaintiff's 150, which was a 2018 to 2020 spreadsheet sales. You got that entire universe of data, those three things from Celsius to look at, correct?
Yes, I did.
So, anywhere in the raw data that you got, was there a product called Flo Fusion?
The only reference to Flo Fusion was with regard to the tubs, but there was no reference at all to Flo Fusion on any powdered products, powdered stick products.
Right, so sticks, whether they're in a box or separate, there was no reference to that.
Correct.
Just powder products. Regardless of the label, it just said powder products.
It identified by flavor.
Oh, okay. So flavor, but not specific to the label, like what the label looks like, whether it's at Flo Fusion, whether it's at Celsius. That you couldn't tell from the data, any of that, correct?
No.
All right, now you prepared several schedules, basically. You kind of took the data and put it in a format, what would we call it, summarizing it or just?
Summarizing it will be accurate, yes.
Okay. Were the powder products profitable?
Based on the information that I received, yes.
Okay.
And that would be before royalty payments, but yes.
Okay. Now, before we get to the any royalty payments or the calculations of $1 million in revenue or 690, I just want to ask you some general questions. You were, Your Honor, may I move the easel out here?
Yes, that's fine.
Thank you.
And if you need to move around, that's fine. Who's doing cross?
Should have done this a little earlier. I'll put it here so Your Honor can see. Oh, no. If it's okay with you, they're not.
I can move it.
Thank you. So, I want you to assume, for for purposes of this next question, that there was a contract signed between Celsius and the plaintiffs in this case dated end of March 2014, okay?
Yes.
All right, so if we want to look at the year before the contract, the 12 months before the contract, which I guess would be 2013 quarter one, or no, not including quarter one, so quarter 2, 3, 4, and 2014 quarter 1, just before the contract was signed, what was Celsius's total revenue?
$12,138,013.
Do you mind if I write 12.1 million?
Your
That's-
Honor, can you go sidebar?
All right. Here.
Hold on, Your Honor, I'm gonna take the,
All right, we're going to take a 10-minute break. All right, so there you go.
Jury's answering?
Everyone can be seated. All right, we can continue.
Thank you, Your Honor. All right, so now for the 12 months after March 2014, in other words, ending in March 2015, 12 months from March 2014 to March 2015, what was the revenue?
$15,391,632.
Okay, and then what I'm calling year 2, which is the 12 months, the next 12 months, from March 2015 to March 2016.
Right, it would actually be after March 31st. So it would be April of 15 through March of 16. That would be $16,247,524.
All right, and then the 12 months after that?
The revenue would have been, was $25,082,810.
Just 25 even if I'm...
If you're going to round down slightly, yes.
Okay, and then the 12 months after that, last question.
Would be $42,233,611.
42.3.
42.2.
22. Thank you. All right, can we pull up plaintiff's 284, 100, and this, so you prepared some summaries, correct?
Yes, I did.
And plaintiff's 284 has been admitted into evidence. We're going to look at the revenue data specific to Flow Fusion in more detail. So what does this represent? What plaintiff's 284 is?
This represents a summary of the Celsius sales data that was provided to me by month. And this is gross revenue for all powder products.
Okay. And can you explain what a trailing, let's see if I get this right, trailing 12-month, I don't know, what's it called? Trailing
12-month period. So the trailing 12 months are the 12 months that end on a specific date. So most people are used, the trailing 12 months at December 31st would be the calendar year. But a trailing 12 months for example, the first one where there's a number would be February of 2015, so that would start in March of 2014 and go through the end of February 2015. That's the trailing 12 months.
So you could look at any 12-month period in certain 2 years. You could look at the first month plus 12 or plus 11, I guess. Then you look at the second month plus 11 months, and you look at the third. So you could look at any 12-month period during a certain term.
Right. That's what that 12-month, trailing 12 months designates a 12-month period.
Okay. And this goes from March 24 to October 2018?
The sales data goes from, March of 2014 to October of 2018.
The sales data that's summarized here, correct?
Yes, this is the second page of the document, so there are other numbers on the first page and the first 2 columns, but yes.
So this is going to be in evidence, but Andre, let's show the first page too. And basically, in the left-hand column, when they look at the month and year, that's going forward 12 months from that date, forward from that date 12 months.
Going back. Trailing 12 months is going backwards. So we have the data that I have started in March of 14. So February of 15 is the 12 months preceding that.
Right, but your column, the first column, the very first thing when the jury looks at total gross revenue, it says March 2014. So you've got to be going forward 12 months.
In the very first column, the very first column has a total at top, which is the total for everything.
All right.
Then the numbers below are the monthly totals in the very first
Andre,
column.
highlight what you just said, total gross revenue, 1.47. Okay, now take away that highlight and go to the right below it, 3/2014. Okay, you see that?
Yes.
So that's going forward 12 months or back?
No, that is a month. That is a single
I
month.
understand, that's a single month. So
Right.
then the next column, April, is just 2 months. And
No, okay, so the first column is the monthly sales. That's what that data is. The second column shows trailing 12-month numbers, which is why it starts farther down, because I have to have 12 months of data in order to get a trailing 12 months.
I see. So, Andre, please highlight the line that says 2/2015, 56. Oh, higher, higher. So higher, 2/2015. Go across there. So that's the first time we get a 12 months, because you have to wait till you get to the first 12 months.
Correct, so the 550,000 is 12 months.
Now I understand. Okay. So looking at both pages, was there a 12-month period, any 12-month period, I want you to assume that there was a contract that started in March 2014, and I want you to assume, for now, for purposes of this question for the that the contract term went through March 2018. I want you to assume there was an extension, and basically I'm just asking you these dates, March 2014 to October 2018. Was there any period in there? What was the first period where the trailing 12 months exceeded $1 million?
That would have been February 2018.
Okay. So in February 2018, we have a revenue number just for the powder products that exceeds $1 million, correct?
The gross revenue, exceeded, for the 12-month period, exceeded $1 million in February 2018.
And this is even using, you told us about the inconsistencies, the missing cells, the mistakes in the Celsius data, but even using their data, in February 2018, you've got over $1 million, correct?
Yes.
All right, now I want to ask you a slightly different question. Counsel, with the last witness, put into evidence Defendant's Exhibit 6, which was some emails going back and forth in the negotiation of the 2014 contract. And I'd like to look at page 4. This is an email from Jerry David to David Gold. The jurors know, I think, that Jerry David is Celsius, the CEO. I want you to pull out a line that begins at about 250 GAAP. Thank you. So, Celsius said in this email, 250,000 shares up front and 250 shares when revenues on the Coke branded product reach 1 million. Now that's different, right? If you're just saying total revenues reach 1 million, you don't have to look at any 12-month period. You could go 13 months, 14 months, 15, correct?
Yes, this doesn't specify for a 12-month period what you showed me right here.
All right, so let's go back to your schedule and you can say, when did the powder products reach $1 million in revenue? Even on their data.
And I'm going to have to look at it. I'm going to have to look and see if I have it totaled differently, because I do not have a cumulative balance on this one. So obviously, let's see.
It's got to be in 2015. Can we agree on that?
Well, okay. Through April 10th of 2016, the total revenue was $1,478,242. As you can see at the top of page 1. So I can back off and pull out the 478,000 to tell you approximately which month it was.
Could you do that? How long would it take?
Let's see. Well, I don't have a calculator with me. looks like it would have been somewhere around the last quarter of 2015.
Last quarter of 2000.
I mean, I'm rounding and guesstimating right now.
Well, you know for sure it was months before April 2016.
Yes.
Objection mischaracterized.
Overall.
And just to be clear, all this data in Plaintiff's 284 is just powder, no cans.
When,
It's powder products.
powder products, no ready-to-drink products, yes.
And there's no way from the data to say what's Flow Fusion and what's not.
Correct. The sales data provided only did differentiated by flavors, and I don't recall whether any flavors had even been introduced at that point in time.
All right, please pull up Plaintiff's 286. So I want you to assume we have a contract with two benchmarks. One involves $1 million in revenue, the other involves 690,000 units. If I ask you questions with the word 690,000 or the number 690,000, that's why I want you to assume that. So looking at Celsius data on Plaintiff's 285, and by the way, I know you probably don't know the plaintiff number, so if you need me to show you a document, let me know. But what I'm asking about now is, actually I'm looking at 286. I want to look at unit sales, okay? I want to look at sales of powder, not by revenue, but by unit. Do you have a schedule where you added up as best you could from the data they gave you the sales of the product?
Yes, that would be the schedule that you have on the screen.
Okay, and at the top it says Celsius, powdered sticks, and tubs.
Yes.
So you can tell from the data when it's a tub, correct?
Yes.
Okay. And I'm going to ask you a very specific question. From the Celsius data, how many sticks and tubs of powder, how many sticks and tubs of powder were sold between March 2014 and February 2015?
738,773.
And now this is going to be a strange question, but is 738,773 more than 690,000?
Yes, it is.
Now let's look at 285. Okay, so I'm going to ask you a slightly different question. So instead of talking about sticks as a unit, or just my question for you is instead of adding up sticks, we're going to add up boxes. Okay, boxes and tubs. So even according to the Celsius data, as you got it, with the limitations you already told us about, how many tubs and boxes of powder sticks were sold from March 2014 through September 2019?
728,247.
Okay, and again, is that more than 690,000?
Yes.
Okay, so I'm just going to do, the last thing we have to talk about, will just take a minute. Let's put up Plaintiff's 287. You did some royalty calculations?
Yes.
Okay, so Plaintiff's 287 covers what product? Is that sparkling, ready to drink? You don't even need to pull it up. I just got two questions. Is
Yes.
Plaintiff's 287 sparkling, ready to drink?
Yes, that's ready to drink orange flavor, yes.
That's in evidence, and the jury can look at it. And Plaintiff's 288, what product is that for?
I need to see 288
Okay,
to tell
pull
you.
up 288. Yeah, you said that. It's my fault.
This would be boxes of powdered sticks for berry and orange flavors.
And the reason you picked berry and orange is you couldn't look at Flow Fusion because it's not detailed in the data that way, right?
Correct. It just indicates the flavor. It does not have a description that says for the powdered boxes, the powdered sticks, Flow Fusion.
You may not know the answer to this, which you say I don't know to any question you don't know the answer to, but did you know that those were the flavors that Flow Fusion came in?
I was aware of that, yes.
All right, that's all I have. Thank you.
cross-examination.
Good afternoon, Ms. Flo.
Good afternoon.
Under the language of the 2014 agreement, do you agree with me that that $1 million in gross co-branded revenue had to be earned within a trailing 12-month period during the term of the contract?
Your Honor, that calls for a legal conclusion in the interpretation of the contract. It's beyond the scope of direct and it's
All
beyond
right,
the scope of her capacity.
I'm going to sustain the objection as, to the question as phrased. If you want to rephrase that.
Ms. Ford, when you did your calculations, was your original schedule under a trailing 12-month period for the $1 million revenue benchmark?
Yes, my original schedule,
I could pull it up again. It's your claim
Yes.
exhibit 284.
if you could pull that up just so I can make sure I'm answering to what you're asking.
Okay, so you want... I had to switch it over, sorry. There we go.
Can you do it, please? The claim exhibit 284.
Andre, can you do that, please?
Sorry about that. Okay, Ms. Fowle represents to you that this is plaintiff's exhibit 284. Based on your calculations, it is your opinion that the $1 million revenue benchmark was met in February of 2018, correct?
No, what I did is I calculated the trailing 12 months, and I was asked during what period $1 million was reached. So that would be February of 2018.
So these revenue calculations, your trailing 12 months is beginning on sales data from March 2017 to February 2018, correct?
Correct.
So assuming your calculations are correct, you would agree with me that this $1 million trailing 12-month benchmark was not met before April 11th of 2016, correct?
This sales did not, for any 12-month period, did not exceed $1 million before April of 2016.
And now, I'm sorry, Andre, would you mind putting up plaintiff's exhibit 285? I appreciate it. Thank you. Ms. Ford, with respect to the 690,000 unit goal, you agree with me that if you count a 14-count box of powder sticks as a single unit, that 690,000 unit goal is not met before April 2016, correct?
Again, I did a calculation of the boxes and the sticks in the sales, and before April of 2016, it did not reach a level of 690,000.
And in these calculations, you are including sales of 14-count boxes when you, apologies, let me rephrase. Can you go to the second page of this exhibit? Thank you. When you're getting this calculation for September of 2019, for this 690,000 unit benchmark of powdered boxes, you're including sales of 14-count boxes after October of 2018, correct?
Yes.
And I'm sorry, can you go back to the first page? And in the beginnings of your calculations, you start counting the sale of all powdered products as of March 2014, correct?
Yes, this calculation includes that.
And you included 7-count boxes in your calculations, is that right?
In this calculation, yes.
Even though you're aware that Flow Fusion was never processed in a 7-count box?
Again, there was no differentiation in the data between flow fusion and non-flow fusion data, so I counted sticks.
But there was a differentiation in the data between 7-count boxes and 14-count boxes, correct?
Yes,
And you did include those 7-count boxes in your calculation.
in this particular calculation.
And you were aware that there were 14-count boxes sold?
Well, no, I'm sorry. I need to correct that. No, this is boxes. In the boxes, there are no 7-count boxes. This is only 14-count here. I
Okay.
apologize.
No, thank you for that clarification. You were aware that the 14-count boxes of Flow Fusion did not exist in March of 2014, correct?
No, as I said, there was no differentiation, and the data here shows the counts of sticks, but the boxes of sticks by flavor. I did not differentiate because there was no differentiation in the data.
So it's your opinion, Ms. Ford, that the only way that the plaintiffs get to that 690,000 unit benchmark is if you treat a single box as 14 units, correct?
Just for clarity, I object. She doesn't have opinions about benchmarks and contracts. I would just ask that she ask.
Rephrase.
All right. Is it your conclusion that the 690,000 unit goal is met only where you treat an individual stick as a single unit, as an individual unit?
Could you repeat that one more time? I'm trying to
Sure.
make sure I understand.
You know what? It might help to pull up. I'll pull up your actual schedule to help you. That would be Plaintiff's Exhibit 286. Okay, so your conclusion that the 690,000 unit benchmark is met is solely based on the calculation where an individual stick is a unit, correct?
No, I think that mischaracterizes what I did.
Okay, well, can you explain?
Yes, the 738,773 cumulative balance in February of 2015 is based on sticks, but that number increases over time. So whether they would have met the 690,000 benchmark, as you're referring to, in February or a later date, based on the numbers, they sold more than 690,000 sticks at some point in time. So this calculation shows it at February of 2015.
Right, and my point is you're using this as individual sticks. This is your schedule with respect to individual sticks and such, correct?
Yes, as indicated at the top of the schedule.
Great. Okay, so moving on, with respect to the 2016 royalties and your calculations there, do you agree with me, Ms. Ford, that in terms of the total, that the only scenario under which Celsius would have to pay royalties under the 2016 agreement is if you look at sales past October 11, 2018?
Objection, Your Honor. That calls for a legal conclusion. We're not in capacity.
Hang on. Objection. Sustained. Rephrase.
Okay. Would you mind holding up Plaintiff's Exhibit 287? Thank you. All right, so with respect to the 2016 royalties, when you're looking at the domestic sales of the ready-to-drink orange, can you actually, well, don't worry about it. If you look at the line item for October of 2018, you agree with me that your findings show that the amount owed in royalties, or the amount that had been earned in royalties at that point, was $117,582.70 as of the end of October of 2018, correct?
Yes, yes.
And Plaintiff's Exhibit 288? And would you mind switching to the next page? Thank you. And you'd agree with me, Ms. Ford, that at the end of October of 2018, the total amount earned in royalties for the 14-count boxes were under $280,000, correct?
Yes,
All right. And if you add up that $278,820 in royalties for the domestic sales of powdered boxes of 6 in orange and berry, and you add up that $117,582.70 for the red drink orange, that is less than $500,000, correct?
yeah, I believe so.
Okay, I have no further questions. Thank you.
There are two things. First, a clarification, and then to come back to something that I forgot to, if the council will allow me. You did calculations in terms of units, the amount of units that added up to more, that strange question, is that more than 690,000? You did that for tubs and sticks, right?
Yes.
How many sticks and tubs? But you also did it and found the date when it exceeded 690,000 for boxes and tubs.
Yes.
All right. And then I had asked you, so with council's permission, because this is beyond the scope of cross, but I had asked you, I said you would check to see how much you had earned. So if there's no objection.
No objection.
Were you able to check that? And so first of all, you're getting paid to be here, for your time recently since you left that company, correct?
Yes, I am.
But before you left the company, have you looked up at the?
Yes.
Can you tell us approximately how much you charged?
So my previous firm charged approximately $68,000.
Okay, thank you. I have nothing further.
Any recross on those limited areas?
No, Your Honor.
Any questions from the jury? All right, you're excused. All right, plaintiff, call your next witness.
Your Honor, may I publish an interrogatory answer and 2 responses to request to produce?
I need to offer into evidence
Well-
Exhibit 277, which is the request to produce.
No, I'm not putting any evidence. I'm just going to publish it to the jury. I don't think it's appropriate. I don't think it's evidence. Without the objection. Yes. May I publish these to the jury, Your Honor?
Yes, hang on 1 second. Do you want an instruction on? I'm not sure if there is one on that.
Yeah, I don't recall an instruction on that, but I'm getting old.
All right, these are interrogatory responses, right?
Yes, an interrogatory answer and
All right, I don't think this has been read yet, but members of the jury, answers to interrogatories will now be read to you. Interrogatories are written questions that have been presented before trial by one party to another. They are answered under oath. You are to consider and weigh these questions and answers as you would any other evidence in the case. You may proceed.
Thank you, Your Honor. So the question from the plaintiffs to the defendant was, are there any differences in the product formula, supplement facts, or ingredients between the powder products referred to as Celsius On-the-Go Sticks and Celsius Flow Fusion when comparing the same flavors? If so, please identify in detail each of those differences when comparing the same flavors between Celsius On-the-Go Powder Sticks and Celsius Flow Fusion. Answer. There is no difference in product formula, supplement facts, or ingredients between the orange On-the-Go Sticks and the co-branded orange Flow Fusion Sticks, except the packaging. There is no difference in product formula, supplement facts, or ingredients between the berry On-the-Go Sticks and the co-branded Celsius Flow Fusion Sticks. And then I have request, and these are all without objection, Your Honor. A request to produce all monthly and annual royalty analysis calculations, ledgers, and reports prepared by Celsius relating to any amounts earned or paid to plaintiff between March 2014 and December 2020. Response, none. And then one more, all internal communication by and among Celsius employees, officers, representatives, and personnel, including electronically stored information relating to Celsius accounting and calculation of royalties earned or paid to any plaintiff. Response, defendant has searched diligently and does not believe any responsive document to this request exists. Your Honor, at this time, with the court's permission, we can put in documents at a later time, but subject to being able to do that, we have no further witnesses than we would. My partner has reminded me that I said documents, but I mean evidence. There are some other things with that.
It's subject to moving in additional exhibits.
We rest.
Plaintiff rests. All right. Members of the jury, I need to take up some matters outside your presence. So I'm going to send you back into the jury room. Hopefully we'll be short. And so we're going to take a little break.
Notebooks on the chairs, please.
afternoon, Your Honor.
Again, Matthew Dillard for the plaintiffs. Your Honor, as the court is aware, the standard for granting directed verdict is that the court is to consider all inferences in favor of the non-moving party, and the court must view that evidence with all those inferences in fact. And the court can only direct a verdict when there's no proper view of the evidence. There is ample and overwhelming evidence that establishes, and Your Honor, I will do my best to be brief like opposing counsel, but allow me to just address this. As the court's aware for both issues, the elements are whether or not there's a valid contract, a material breach, and third damages. That is what the plaintiffs are required with respect to all of the breaches here. There's no dispute about the evidence regarding that there were valid contracts. The 2014 and 2016 endorsement agreements are in evidence. There's testimony from the parties, including Mr. Prince and Mr. Dillard. And with respect to that, we're getting to the real issue of the breach. And I just want to note these grounds. Now, with respect to whether or not there was $1 million in co-branded revenue, Your Honor has heard testimony that the contract was intended with the language of two terms. There's a differentiation between bonus compensation, its provision, as well as the incentive compensation provision. There has been testimony from the plaintiffs of what their intent and what they interpreted that to mean. The jury is also entitled to give meaning to the different uses of those terms, including plain meaning, and that alone would suffice for them to return a verdict on both those counts. There's also been testimony regarding whether or not plaintiffs met those benchmarks. And with respect to co-branded revenue, we have seen in evidence the schedules, as well as 10Ks and 10Qs of the defendant, as well as expert testimony from Ms. Bohr that explained when the co-branded revenue benchmark was met with respect to $1 million. With respect to whether or not units, 690,000, were sold, first, again, the jury is allowed to use plain meaning in interpreting the contract. There's been testimony in terms of all of the plaintiff's witnesses about what they understood a unit to mean based on their understanding, based on their own experience in the industry, based on their conversations with members of the defendant's organization. The jury is also allowed to use, again, plain meaning in interpreting it, and there will be in evidence the actual units. Also in evidence, Your Honor, are numerous documents, and again, I will not belabor the point, but there are documents from the defendant's own records that are in evidence. And again, I'm just going to highlight a couple. Plaintiffs' Exhibits 5, 7, 10, 119, 120, and 256 are all documents from defendant's own records that evidence promotions, internal communications, marketing materials, and conversations with other customers such as distributors about what they define as a unit. And those documents all evidence that the defendants understood sticks to be units, they understood tubs to be units, they understood individual ready-to-drink cans to be units. We've also heard testimony from Ms. Bohr and seen in her schedules that the plaintiffs met those sales of 690,000 units. And again, we've heard testimony and we've seen in the schedules that they made that benchmark under even the defendant's interpretation of a box. With respect to the benchmark data as well, Your Honor, I'm getting us to the question of whether or not the defendants have this as a continuation or as they argue that it was two separate agreements. Again, the defendants have one interpretation, but there is ample evidence that the jury can consider. First, with respect to the contracts, they are allowed to use plain meaning and understand that the terms were expended. They are allowed to consider, and before them is testimony from Mr. Gold, as well as Mr. Dillard and other parties that this was a renewal. There are internal documents from the defendants that evidence that the agreement from 2016 was a continuation and expansion. And again, I'm highlighting Plaintiff's Exhibit 65, 68, 64, 100, and all those documents are communications or press releases or board minutes by defendants that use the word renewal. and evidence that the intent was to continue and not to eliminate the 2014 agreement. With respect to performance of the contracts, the plaintiffs, and I know this has not been raised in dispute, but just for a record, there's significant evidence of the plaintiff's performance. And again, plaintiffs 118, 21, 23, 25, and again, numerous other exhibits as well as testimony from multiple witnesses, including Mr. Prince, Mr. Dillard, Mr. Gold, Mr. Bousset, all evidence that Mr. Dillard and D3M performed. And they performed in excess of any of the obligations that were required. With respect to all drinks being co-branded revenue, as the defendants have contested, again, exhibits 6, 16, 20, 27, 35, 160 through 162, and multiple other exhibits, as well as testimony from the plaintiffs, show, and as well as the defendant's witnesses who were testifying through video deposition, demonstrate that Mr. Dillard was branding the entire company. He was promoting Celsius drinks and the powders, and that all revenue, including ready-to-drinks, constitute co-branded revenue. The jury has also received significant and overwhelming evidence with respect to the damages in this case. Excuse me, let me back up in terms of the breach. And I know defense counsel has raised the date of breach issue, which Your Honor's already ruled on, but there's been ample evidence of multiple dates of breach. There's been evidence of the benchmarks met, the failure to deliver stock, and again, that's been put into evidence through testimony from both the expert in terms of the benchmarks, the data that's in evidence, the testimony from Mr. Gold and Mr. Dillard about the demand for the delivery of stock, as well as documents evidencing that the defendants did not produce any stock. Again, with respect to the valuation of stock, Your Honor, there's ample evidence that the plaintiffs intended to hold the stock, that they intended to possess the stock, that it was not their intent to sell it. And again, unless the court wants to revisit that issue in the argument, there is evidence that supports the plaintiff's view of when they intended to hold the stock and for how long. Turning to the evidence of damages, though, Your Honor, in addition to that plaintiff's testimony, there is the letter denying the delivery of stock by the defendant, as well as evidence that defendants never produced any stock throughout the termination of the contract period to present. With respect to royalties, Your Honor, the defendants have argued that, again, there's insufficient evidence, but again, the testimony from Mr. Dillard and Mr. Gold establishes that their intent was to have royalties. I want to point out the evidence is not required here to show that the defendants needed perpetual royalties, but that the defendants breached by failing to pay royalties that are owed. So, yes, the plaintiffs do believe they're entitled to royalties because there's no timeline of expiration, which the jury can infer, but again, that's not required. Finally, Your Honor, and I know this has been raised, the defendants have raised the defense of statute of limitations, and again, the plaintiffs have alleged, and there's sufficient evidence to show unclean hands, fraudulent concealment, equitable estoppel. All of these theories are hinged in the breach of the duty of good faith. They all speak to the issue that, as the defendant's witnesses have testified, as their documents have showed, there's been no production of data. There was no information regarding accounting of any of the royalties or stock delivery benchmarks, and that when plaintiffs consistently represented that they wanted an accounting, the defendants denied it and actually misrepresented that powders were failing. It came from both the CEO, current and former. So for those reasons, the defense of statute of limitations evidence is sufficient to overcome any direct verdict on those points. And with that, unless the court has any questions, I will submit.
I do have one question, and that's the last argument that was made. I know all of this was raised at summary judgment. Certainly it's preserved. Obviously, we're making those arguments again today. We're just going to have one verdict form, correct?
Yes.
And so I know there's the argument that was made early on that neither Strong Arm Productions or Mr. Dillard have standing. That's been made preserved, but we're not going to have a separate verdict form for each. So they'll all be on together. I appreciate your argument on that. And I know that the contracting party was D3M, but all three were named in the contract. And
Yes, Your Honor,
so-
just to clarify, it's not so much a standing issue as it is they haven't suffered damages. Because the payments that are being claimed that were supposed to be made but weren't are payments that were supposed to go to D3M.
No, I understand, but either way, it's one verdict form. It's not going to be double counting. You're not
Right,
going to have
and that's the
a
concern.
split verdict or anything of that nature. They'll all be on the same verdict form, so I'm not too concerned about that. All right, anything in response?
Nothing
Or reply?
further, Your Honor.
I'm going to deny all the motions. They're all preserved. I addressed all these issues at the time of the summary judgment hearing, as well as one of the issues having to do with damages and stock price. I would say addressed as part of the motions eliminate. I do find these are factual questions for the jury to decide and to draw on all reasonable inferences in favor of the plaintiff at this point. This is for the jury to decide after weighing the evidence and the credibility of the witnesses. All right, so obviously you still want to figure out the exhibits. We'll go to defense case. I know you brought one witness here, and then we have one standing by on Zoom. I don't see how we get both of them done in an hour, but which one do you want to do first? The only reason I ask that, if we're going to do handle the witness by Zoom, I think there was a glitch in the internet, and so I think I have to reboot my computer, and I don't even know if they're still in the waiting room for Zoom.
They are. Well,
Is that the one you want to do next, or
Yes,
do you want to take
yes,
the
Your
witness
Honor.
that's here?
we need to do Mr. David because this is the only day he's available.
Okay.
So we're obviously going to have to
all
squeeze
right.
it in.
Well, let's go grab the jury.
Your Honor, can we remove the
I was-
Yeah, we'll take care of all that. We're going to move everything here, and hopefully by the time you get the jury back, we'll have all the Zoom set up. But I do have to read.
Your Honor, it's the same.
Can you actually just,
meeting
in case it falls, can you just like rip that off and keep that?
It's the same meeting ID, Your Honor.
All right. I hope that's going to still be on, though. That's the question. I think they went home at 3:30, so I'm hoping between our two tech guys here that we can figure this out.
Yep.
If anyone needs a
It's over. It's not fair to us.
are you okay? Do you need a break? I can. Should you positive? I can stop them now and hold off. Okay, I should have done that first, but I know we're going to try and get this last witness done tonight. Okay.
Rebecca, Mr. Buckner's here. He just popped his head in and let him know what's going on.
Thank you for
I think he'll be tomorrow.
He's
So.
probably going, that's going on.
Thank you.
Your Honor, I'm going to step outside, but you can go ahead without me.
Okay. Yeah, I probably shouldn't have grabbed the jury yet. They might be sitting outside for a second. All right. Yeah. So yeah. Okay, she doesn't. All right, everyone could be seated. All right, are all your screens working? Yes? Okay, perfect. All right, we're now shifting over to the defense case. All right, defense, call your first witness.
Yeah, David.
All right, and as you can see, the next witness is coming to us via Zoom. And so they'll be on the screen there. And so, sir, raise your right hand. You solemnly swear affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right, go ahead and put your hand down, state your name, spell your name for the court report.
My name is Jerry David, Gerry David.
All right, you may inquire.
Thank you, Your Honor. Good afternoon, Jerry. Can you hear me?
I can. Good afternoon.
Hey, Jerry, for the benefit of the jury, where are you testifying from?
I'm in Lakewood Ranch, Florida, near Sarasota, Bradenton area.
Jerry, you had some surgery recently, and are you currently on any medication that would affect your memory today?
I am not.
And are you on any medication that would affect your ability to testify truthfully today?
No, I'm not.
Okay. Tell the jury a little bit about yourself. Where were you born, and what do you do for a living?
I was born in Michigan, on the east side of Detroit. I was back in 1952, so I'm 70 years old right now. And right now I'm retired. I retired back in 2017 at Celsius in March of 2017. I've stayed active. I'm on the boards of 6 companies currently and being active in those. That's what I'm doing.
Are you married?
I am married for 48 years.
Do you have any children?
We have 1 child.
What's his name?
His name is Toby David.
Is he an employee of Celsius?
Yes, he is.
You mentioned you're retired from Celsius. When did you first start working at Celsius?
I joined Celsius in October of 2011.
And what were the circumstances surrounding your starting to work at Celsius in 2011?
I was contacted by a search firm that Mr. Carl DeSantis had employed to reach out to me related to helping turn around Celsius, the business.
And who is Mr. Carl DeSantis?
Carl DeSantis was a major shareholder in Celsius from early on in the company, and at the time that they contacted me, Carl had taken control of the company with a 52+% ownership in the business. And
what
so he was really...
And what was the position you were brought in to take at Celsius in 2011?
I was brought in as president and CEO.
And what was your immediate function or obligation when you became CEO in 2011? What were you asked to do with respect to Celsius at the time?
Carl reached out to me because of my background and the ability that I developed to turn around companies. And Celsius was really in serious trouble at the time I came in. And my mission and goal was to get Celsius turned around and getting it on the right track for growth.
At the time that you started Celsius, how many other companies have you assisted in turning them around, so to speak?
Celsius was my 5th turnaround.
All right.
And by the way, the toughest. Okay.
All right, and tell the jury, just very briefly, exactly what you did to turn around Celsius.
Well, I had developed over the years a way that I go about it. And the first thing I did was I wanted to get under what I call the skin of the company. And we had 12 employees at the time, roughly. And I met with each of the employees individually, got to know them, got to understand through them some of their concerns and thoughts about the company. And then I delved into the financial structure of the company. I delved into the marketing, finance, operational side of it. And I my plan was in a 90-day period, I would come out of that 90 days of my investigative work with a plan that would, my turnaround plan.
As a result of your efforts, did the company improve financially in 2012?
We had a record year in revenue in 2012, and that was even considering that Costco, which represented 40% of our business at the time, summoned me to their headquarters, and they ended up pulling us in September of that year off the shelves.
And did Celsius make further improvements in 2013?
Yes, we had another record year back-to-back with 2012.
So by 2014, is it fair to say that the company was in an upward trajectory, at least with respect to its financial performance?
Well, we were definitely moving in a strong direction and growth on the revenue side. We were still at that time losing, money, but that was expected. And we were investing in building our staff, and I brought in new management and so forth. So yes, we were moving in the right direction and moving very strong.
All right. So let's fast forward to 2014. In early 2014, was Celsius approached with respect to a potential opportunity for a celebrity endorser to promote its products?
I was contacted by a young man, his name was John Bagnano, or I believe that's how you pronounce it,
Right.
that started to contact me and repeatedly contacted me, and finally I gave in, and I was busy with so many things, and he came in and met with me, and he presented to me the possibility of engaging with Flo Rida. And at the time, I really didn't know who Flo Rida was, but I did my own investigative work.
All right. And as a result of that investigative work, what did you decide on behalf of Celsius, at least with respect to the opportunity to engage Flo Rida?
Well, I really liked what I saw and read about Flo, but what was important to me at the right time is before we ever would engage with somebody as a spokesperson or brand ambassador for us, I would want to meet that person and spend time with that person to get to know them.
And did you do that at least with respect to Mr. Dillard, Flo Rida?
Yes, I did.
So you actually had an in-person meeting with him, correct?
That's correct.
And you were satisfied as a result of that meeting that you wanted to move forward and try to negotiate a transaction with Mr. Dillard and his representatives?
Yes, after I met with Flo and was able to determine his character and so forth, then I decided he would be a good fit for our company, yes.
So let's go ahead and, now, with regard to the negotiations, were there emails exchanged between you and representatives of Flo Rida with regard to the potential terms of an agreement, an endorsement agreement?
All of my work related to negotiations was done through a company called D3M.
And that was through Mr. Gold?
Yes.
Scott, put up numbers, defense 6.
Yes.
Mr. David, can you see this document?
I have to put my glasses on, yes.
All right. So this is Defense Exhibit 6. It's already in evidence, but I just want to ask you some questions about some of the language in the documents. And Scott, if you can go to page 5 and 6. So we've already had some testimony about this, Mr. David, but this is an email from Mr. Gold to you dated February 7, 2014, with regard to discussions of potential terms of an endorsement agreement, and I want to go to the next page, and I just wanted to address the point 1, which says licensing endorsement co-branded line of Flo Rida Celsius powders, number 1, 2-year licensing with auto renew. Do you see that there?
Yes, I do.
Was that term acceptable to you on behalf of Celsius?
It was not acceptable to me.
Why was this term, this proposed term, not acceptable to you?
Well, first, we had no experience at this point with our relationship with Flo, and I would never put an auto renew into any contract like this with an endorser or somebody that was a spokesperson.
Now, was the purpose of this negotiation, at least from and I want you to discuss this or talk about this from Celsius's perspective. What was Celsius's perspective with regard to the product that was going to be endorsed by Flo Rida?
Could you ask that question one more time, please?
Sure. What was Celsius's understanding of the product that was going to be endorsed by Flo Rida?
Well, Flo was hired under this contract as a spokesperson for the company, the Celsius brand, primarily. And during our negotiations with D3M, they brought up that they would like to have a co-branded product with Flo as well. So the original intent when you bring on the spokesperson is really to promote the company, the Celsius brand, and through our discussions with them, they wanted to have a co-branded product.
And what was that co-branded product that they wanted?
Well, I personally would not do an RTD beverage, okay, as a co-branded product. It's very expensive to bring out a co-branded product in an RTD because of the minimum quantity orders of 250,000 cans. So we decided together that we would do a powder product, which we could do lower runs of the product in case that we had to modify things or do things different or if it didn't succeed. So we came out with a 40 count. We decided on a 40 serving canister that we would come out with.
This is what you refer to as the tub?
Yes.
All right. And, okay, let's go to page 4, Scott. And I just want to focus on the bottom here, your email to Mr. Gold of February 20, and specifically the sentence in which you write, "We are prepared to provide 500 shares in the following fashion, 250,000 shares upfront and 250,000 shares when revenues on the co-branded product reach 1M or 1 million." You see that there?
Yes, I do.
So what did you mean when you wrote 250,000 shares when revenues on the co-branded product reach 1 million? What did you mean by co-branded product?
A co-branded product means where you have two different brands on there. In our case, with what we were doing with this relationship, would have been to have Celsius logo on the product, and you'd have the Flo Rida logo on the product. That's what co-branding means. It means you have a singular product, or you could have other products, but they all have the same consistency. They have a Celsius logo on it in this case, and a Flo Rida logo on it. That's what I mean.
Now, there was also another. Ultimately, there was a negotiation which led to the issuance, or at least it was going to be a benchmark of 500,000 shares when 690,000 units were sold. Do you recall that provision?
Yes.
All right. And I'd like to. This is already in evidence. Defense Exhibit 177. So Defense Exhibit 177 is a document dated February 21, 2014 from Bill Milmo to Jerry David. Who's Bill Milmo?
Bill Milmo was the president, and still is today, of Carl DeSantis' holding company. And at the time, Bill was the chairman of the board of Celsius.
I apologize. This is your memo to Mr. Milmo. And in this memo, and I want to go to where it says equity earned. you wrote 500 shares when 690,000 units, and then in the parenthetical, you put 17 million on average are sold from all channels of distribution. Parenthetical, that equates to 1% of Flo's followers ordering 3 times on average. Can you please tell the jury what you meant by that?
We expected from the 690,000 units that it would generate, 17 million in revenue, and that was when I think when I said on an average, I was saying because the price points could be a little bit different no matter where it was being sold, but on average that was what it would generate. The calculation you see there was to show him that if we only were able to get 1% of Flo's people that are his followers to order 3 times, they would generate that type of revenue. And this was on the co-branded product.
So you were hoping to leverage the number of followers that Flo Rida had on social media to induce consumers out there to purchase, in this case, the tubs, correct?
Yes.
So let's go ahead and go to the endorsement agreement of 2014. No, the endorsement agreement. Good one. Thank you. All right. So, Mr. David, I'm showing you Plaintiff's Exhibit number 1, which is the 2014 agreement. And I'm not going to belabor too much of this. This document has been reviewed by a number of people. But the one thing I want to ask you is, prior to the time that this endorsement agreement had been entered, had Celsius reached $1 million in revenue on its products for any 12-month period?
Yes.
And this would have been, for example, had it reached $1 million in gross revenue for, let's say, the sales of ready-to-drink cans, again, prior to the execution of this agreement?
Yes. The answer is yes. We were actually doing multi-millions of dollars at that point in our core line of the ready-to-drink products.
So, from Celsius's perspective, did it make any sense to offer Flo Rida and D3M shares of stock if it meant $1 million of revenue for products other than the co-branded products?
Absolutely not. I mean, if logic prevails, if the company's already doing multi-millions of dollars in those products, if I did agree to an agreement where we gave them those shares, if 1 million was achieved on all products, I might as well hand them the stock right away. I would never, ever consider doing anything like that. It'd be ridiculous.
All right. So your part. So now let's shift and let's talk about units. So we talked about the 690,000 units, and what was your understanding of what was a unit under the terms of the 2014 agreement?
The units were the tubs, the canisters,
right.
The co-brand. Let's put it the co-branded product at the time.
These were the tubs that had the Celsius and Flow Fusion name on it, right?
Yes.
And they had the logo for Flo Rida, right?
Yes, they had the Celsius logo and they had the Flo Rida logo on the canister.
And the idea here is that this product, this unit, would be sold anywhere between $19.95 and $39.95 retail, pursuant to the terms of this endorsement agreement, right?
Yes, that's correct.
Was there ever any discussion with D3M or any of the representatives of Strong Arm that a unit would be the equivalent of 1 stick of powdered product?
I would never agree to that in any agreement. Any agreement that I've done in my 48 years in business related to consumer products, you always tie it to your wholesale price list and how it's distinguished there. The sticks were only sold to our customers, which was the retailers. In fact, our relationship with Amazon was very different from a lot of people on Amazon, where they bought the product from us, they picked the product up from our warehouse, and they owned the product. So they were acting as a distributor to us, okay? So we always went by how we showed it on our pricing sheets, how it was packaged. So the sticks were always going to be a 14-count box was a unit.
Let me, now, did the board of directors of Celsius actually hold a meeting to vote on or to approve the endorsement agreement with D3M and Tramar?
Yes, they had to, because it was not in our budget that was approved, and that anytime we're outside of the budget like that with that kind of money, and also the issuance of stock, we had to go to the board for approval.
And you attended that board meeting?
Yes,
And was that board meeting held on February 26, 2014?
that would have been the date that we would have done it, yes.
And there were minutes prepared with regard to the approval of this agreement in the board of directors meeting?
Yes, there's always minutes at these meetings.
Your Honor, this is plaintiff's exhibit 40, and we'd like to go ahead and move it into evidence.
Any objection?
I apologize, Your Honor. It's changed, but I need a minute to read it.
Is it already in? It's already in.
I'm sorry, Your Honor, it's apparently already in the evidence. It's the plaintiff's, defendant's exhibit 36. I was just going off of the plaintiff's designation.
Then I have no objection.
Sorry about that.
All right, it's already in evidence, so,
All right, so let's go ahead and pull it up. And Jerry, I just want to zero in on, I think on the second page, which has that, where the first check mark is, and this is the check mark that talks about the proposed agreement that was being considered by the board of directors for approval with D3M and Flo Rida, correct?
Correct.
Okay. And just so that I'm clear, at least from Celsius's perspective, at least as it was represented to the board of directors, there's language in the middle of it, and they're talking about the issuance of shares under certain benchmarks, and one of the benchmarks is an addition, 250,000 share are issuable upon achieving 1 million in co-branded product sales. You see that there?
Yes, I do.
So again, from Celsius' perspective, the idea was that additional shares would be earned if there was 1 million in co-branded product sales.
Yes.
Now, did at some point in time Celsius come out with a co-branded box of sticks?
We did later, yes.
Okay. And by the way, before we get into that, how did the sale of the tub canisters fare with Celsius?
The canister tubs went into GNC initially. One of the things that I was to help, we had our best chance of succeeding by going into what we call a specialty store like GNC or somebody like Vitamin Shop, where the personnel in those stores are trained, they're educated on the products, and when you're trying to sell a new product at a price point that the canisters are selling at, our best chance of success would have been to go into that store. So we went into GNC, and the company developed large displays that went in with, the Flo's liked it. We spent a tremendous amount of money trying to have that succeed in GNC, and the fact was it just didn't perform. It didn't resonate with the consumers, and it failed.
So, now, at some point in time, the term of the agreement was coming close to, and I'm talking about the 2014 agreement, was coming close to expiration, correct?
Yes.
All right. And what did Celsius do? What was Celsius's decision at that point with respect to the termination of the oncoming termination of the 2014 agreement? What did Celsius decide to do?
Could you ask that question?
Sure, that was a little awkward. So you agree with me that the term of the agreement was 2 years, correct?
Correct.
Okay. And so at some point there were discussions between Celsius and the B3M and Strong Arm people about the expiration of that agreement, correct?
Yes.
All right. And
323, Scott? Defense?
What year? This is in evidence.
this is an evidence.
What number did you say?
No, I'm sorry.
Just 23. Defense
I may have to move it into evidence. Let me hold it off.
No. Yeah, defense
Hold it up,
23
hold it
is not in evidence.
It's not in evidence. Hold off. All right. So did you have a meeting sometime in February 2016 with regard to, and this would have been a meeting with Flo Rida and Reggie Mathis of Strong Arm with regard to the upcoming termination of the 2014 agreement?
I can't tell you a specific date, and I don't recall if I had a specific meeting with them, but I would, knowing how I operate, yes, I would have probably had a meeting with them to discuss that at the right time.
And would an email around that time refresh your recollection of what happened in February of 2016?
That would help, yes.
I have no objection to putting it together.
All right, so let's go ahead and, Your Honor, move into evidence of Defendant's Exhibit 323.
All right, that's in evidence. I'm sorry, what? 323?
323.
It's 323, not 20. Okay, that's all righty. That makes a difference.
Okay. You see the email there, Mr. David?
Yes, I do.
Does that refresh your memory as to what was going on around February 2016 with regard to the expiration of the 2014 agreement?
Let me take a minute and read this, please.
Certainly.
Okay, I read the meeting. What was the question, please?
And so the question is, did this email refresh your recollection as to what was being discussed in February 2016 with regard to the upcoming termination or expiration of the 2014 agreement?
Well, the attendees in this meeting, being Vanessa Walker, and Linda was there as well. Linda was also in the marketing department at the time, and it appears that we were discussing some marketing strategies and so forth, potentially if we moved on to a new agreement with Flo.
So the D3M Strong Arm people were looking for a new agreement from Celsius, correct?
That's correct.
And at least with regard to, ultimately, a new agreement was reached between Celsius, D3M, and Tramar, correct?
That's correct.
And that was the second agreement, which we designated as the April 2016 agreement. Right?
That was a brand new agreement.
And one of the components in that agreement, in that new agreement, was a royalty component that provided for the payment of royalties to D3M with regard to the ready-to-drink cans, correct?
It was I believe it was like 10 cents a case or something.
And that was not something that was in the 2014 agreement.
Correct.
Last series of questions, Mr. David. In addition to Flo Rida, did Celsius have any other brand ambassadors or celebrity endorsers?
Later that year, we negotiated a relationship as a brand ambassador for the company with Emerson Fittipaldi. Emerson was probably one of the greatest legends in the world's #1 sport, auto racing. He was the 2-time Formula One world champion. He was also the IndyCar champion. He won the Indianapolis 500 several times. And we actually signed a deal with Emerson for globally to represent us, and especially in Brazil, where we were planning on launching in Brazil, which was his home country. Initially, his handlers wanted $7 million up front, and after meeting with Emerson and really bonding with him, and we became immediately close. He agreed to doing an all-stock deal with us back when the stock was trading, at a low price.
And would you consider the endorsement deal that Celsius did with Mr. Fittipaldi successful?
It was successful. We launched in Brazil, and Emerson really was very proactive in Brazil. They had a 6-hour Le Mans race. It was a big race. He actually raced in it at 67 years old for Ferrari. But he had developed on his own these large cardboard likenesses of him holding the can and placed it all throughout this big facility. It was also, he arranged for, as an example, the news organizations in Brazil to all come to him kicking off Celsius in Brazil. He did tremendous things for us down there. What happened in Brazil was that the country changed the laws related to green tea and products, and we were not able to continue in Brazil at the time.
And last question, did Celsius have other celebrities that promoted the product?
Early on in the company, was Mario Lopez was involved, but Mario continued to do that. But what we really got from celebrities was a tremendous amount of free publicity. As an example, Khloe Kardashian, who has 263 million followers, she was doing a video at her house where she went to her refrigerator and showed how she lays out the food in her refrigerator, and in the front row was these Celsius cans, and at the end of when she was presenting this, she actually pulled one of the Celsius cans out and said, "This is my favorite drink." Now that's with 263 million followers. One of the other people that was Howie Mandel. Howie Mandel, during these same years of 14, 15, 16, he was consistently, and later he was doing, he still does it today, is that he posts pictures of himself drinking Celsius while he's working out. We had this, the Mario Lopez continued to do that on a regular basis as well. But one of the biggest celebrities.
And so we can wrap up, Mr. David, we're pressed for time. All these people that were promoting the product, Celsius didn't pay for those promotions, correct?
We never paid them to do that during that period of time. No, in fact, I never spoke to them myself.
Mr. David, thank you very much. I have nothing further to say.
Cross-examination?
Yes, Your Honor. So you just testified, sir, that, first of all, good afternoon.
Thank you. Good afternoon.
You would never, did I hear you correctly, you would never do an auto renew for a branding contract, an endorsement contract?
I would not do an auto renew with a branding ambassador like this until I knew that we had a strong relationship with the person. No. I'm the one that took that out of the agreement.
Yes, so the first contract you signed with Emerson Fittipaldi was July 15th, 2014?
Yes.
First contract, right?
I believe it was the only contract, if I remember correctly.
Because it auto-renewed.
I don't recall it ever auto-renewing.
Okay, so I'm not sure how to do this by Zoom, but I would like to, if there's no objection, show the Fittipaldi endorsement contract between Celsius and Fittipaldi, the term, the paragraph with regard to the term.
It's exhibit.
Sorry.
It's exhibit 48, plaintiff's 48.
So can you blow that up?
Is that already in evidence?
It's not in evidence, Your Honor.
All right, is there an objection to that coming into evidence?
No, Your Honor, no objection.
Are you off?
All right, so that's in evidence. All right, there it is. It's up on the screen.
So paragraph 1 term, Andre, if you can blow that up, it's done. Well, yep, right there. Sir, when he blows it up, hopefully you can see it.
You say you copy.
So take a minute to read it before I ask you questions.
Okay.
And this is right around the same time as the Flo Rida contract?
It was later in that year, I believe.
And you had just met both of these guys?
I met Emerson that year, right?
So you were mistaken when you said you would never agree to an auto renew?
I obviously mistakenly said that.
Okay. It happens.
But just to clarify, when I was negotiating the Flo Rida agreement and they wanted to have the auto renew, I at that time said that I did not want it in that agreement. We did not have it in that agreement.
So you said, well, right, but sir, you said you would never do that. That's not true.
Objection, Your Honor, some slight mischaracterization of his
All
practice.
right, hang on. Is there? I'm going to sustain the objection. Chip, you rephrase your question if you want to go there.
I believe that's an exact quote, isn't it, sir, that you said you would never do that. That's not correct, isn't it? I'm right, it's not correct, right?
Your Honor,
You're correct.
All right, now you told us how much work Mr. Fittipaldi did in regard to his branding to help Celsius. You didn't go through that in regard to Flo Rida, but obviously he did a lot. That you have emails saying awesome and how happy you were, and there were so many things you guys were very happy with for Flo Rida, correct?
There were also a lot of things that I was not happy with. So I had to make a decision before we created a brand new contract with Flo and assess whether or not I wanted to move forward in a brand new contract with them. But there were a lot of things that I was not happy with.
Okay. But I'm just asking you about how you talked a lot about the good things Mr. Fittipaldi said. You're not suggesting that there weren't awesome, in your words and emails, awesome things that Flo Rida did.
There were a lot of things that Flo did. Look, I like Flo a lot. I felt very close to Flo. But there was a lot of deficiencies. Flo had 20 million followers, but every time I would look at when there was a post put out by Flo to his people, I would see numbers like 100 people, 10 people viewed it, 200 people, all numbers that didn't reflect 20 million followers. So I was always worried about that we really weren't getting the traction that we wanted with that group that he had. I was trying to get to that younger group of demographics. But just having 20 million followers, it really amounts on how many people viewed his post. And the numbers were very, very, very low consistently. So that was one of the things I was really concerned about. But Flo did a lot of other very positive things for me and, for the company. And I was happy with it.
Okay, so I know you want to, or you've added something I didn't ask about your negative things about Flo Rida. Is it true that you wrote, for example, there were so many things that you wrote awesome and you were very happy with. There were things that you were very, very happy with about Flo Rida.
Is that a question?
Yeah, yes, sir.
Yeah, so there are things that I was very happy with Flo. I really felt Flo, his personality, his likeness, people, when you meet him, you like him. I liked him. He had a lot of energy to him. I thought his physical fitness and everything fit into our brand extremely well. Again, there was a lot of things that were not good. As an example, I think it was for 3 to 4 months when we first started the relationship with Flo, we couldn't get them to post anything from Flo on the social media. That was critical. I ended up having to send somebody down from our office to Flo's office and work with his people to help them start to put out stuff. So, look, any relationship takes work like this. It's not something that's just magic that happens overnight. But there was a lot of positive things about Flo. You're right, everything you said, but there was a lot of negatives, that were happening within the relationship.
Sir, when I'm done, do you consider Mr. Casal your lawyer?
Please ask that one more
Do
time.
you consider Mr. Casal to be your lawyer? You don't work at Celsius anymore. Do you consider Mr. Casal to be your lawyer?
What was the name again?
The person who was just asking you questions.
That he's my lawyer? No, I don't work at Celsius, no.
Okay. Well, the lawyer for Celsius is going to get up when I'm done and ask you questions. Until then, would it be possible for you to answer my questions and let him ask the questions that you maybe wished I had asked?
Objection, Your Honor. This is, Your Honor, really.
Sustained. All right, ask your next question.
So I'm going to pull up Defendants 245. You said there were 10 posts, 10 people. You said, I'll stay here because I want you to be able to see me. I apologize. Sometimes I feel like I have to move. You said that sometimes there were only 10 people looking at Flo Rida's post. Celsius prepared analyses of these things, right? Where's this page? Is that true they did? They prepared analyses?
I'd have to look at the analysis. I'm sure our marketing department did some, but I would have to see.
And as far as you know, what the marketing department did was accurate, right? I'm just saying in general. Well, you can tell me what you think of this document, but as far as you know, your marketing department was accurate when they were looking at these things, right?
I would have to say my marketing department was accurate. I'm not sure what I'm looking at here because I'm not sure that says views. That looks like the reach. I'm not sure that means views.
Okay, so what you guys reported was 18 posts to the end of October, right?
Yes.
So from the contract signing just into October, March to October, there were 18 posts, and on Facebook, there were 27, reaching 27 million people, correct?
Correct.
And then for Instagram, it says plus plus. They don't estimate that, but there's more on Instagram. Can we do that little chart, Andre, where it says FB 27, Instagram plus plus, Twitter plus plus? Correct?
I see that, yes.
All right. Now, you talked a little bit about your sales through, Mr. Gold's testimony about sales through Amazon, correct?
I didn't hear his testimony, no.
Okay, what were you telling us about Amazon?
When you were asking a question about who our customers were, I said Amazon, as an example, is our customer because we sell the product to Amazon. They pick it up in their own trucks from our warehouse, and then they own it from our dock. They own it. That's not how all people sell on Amazon. So I just wanted, as we were discussing who our customers were and who we were selling to, I wanted to make sure that even on the online business, that it was not, our Amazon was acting as a distributor, we were not selling direct to the consumer ourselves.
Okay, and you also had accounts like, I think it was GNC, where you gave them the product without them paying for it, and they actually didn't pay until the sticks were, or whatever it was, were scanned in the store, and the customer paid, and then they gave part of that to you, right?
I don't remember that, but that would be a pay on scan.
Right, and you had pay on scan, whether it was GNC, well, you guys had pay on scan, correct? With some stores.
No. Well, I would have to say to you that to answer that pay and scan is only used when the company we're selling to doesn't want to prepay for the product like most people do. They didn't even want to work on terms. So when people go to pay on scan, that means they don't have that much confidence in the product.
Yeah, I understand, and you guys don't like it. You want to get paid rather than shipping product for free and then getting paid when the customer buys it. But you still did it, right?
If logically, any company would want to be paid ahead, up front or with terms of 30 days or something versus pay on scan. You're right.
So you mentioned Khloe Kardashian, the 283 million followers, and she did something with Celsius. That was a big deal.
Well, I was shocked and surprised that she did that because when she did that. By the way, she did not do that, I don't believe, just for Celsius. It was a video regarding something else that she was talking about her refrigerator and how she organizes her refrigerator. So, I don't believe she did that. That was not promoting Celsius. It just happened in her conversation that she pulled it out of the refrigerator.
So, who is Kevin Harrington?
Kevin Harrington is a gentleman that was on the board of directors of Celsius, and Kevin and I worked together back 25 years ago when I was executive vice president of International for Home Shopping Network. Kevin was the CEO of the same group that was the infomercial group, where we were selling products, consumer products, in 72 countries.
He was on the board of Celsius, correct?
That's correct.
Okay, and so I'm going to play now, without objection, the transcript was marked as Plaintiff's Exhibit A for identification. I'm going to play the video.
All right, is this coming into evidence?
Yes, I will move it into evidence.
All right, as what number?
290, Your Honor.
All right, no objection?
No objection.
All right, so plaintiff's 290 is in evidence.
Campaign campaigns that I was involved with, an energy drink called Celsius.
Of course.
And with Celsius, this was a situation where we had a connection to Flo Rida, and Flo had 26 million followers. He starts putting out some videos. Some of his followers listening, Khloe Kardashian, happened to say, hey, Flo, I'd like to try some of that Celsius.
Yeah.
We sent her a few cases, and then she was tweeting absolutely free.
Content is so engaging that other celebrities enjoy following the other influencers.
Right.
And yeah, like I said, they've become celebrities in their own rights as well.
In their own right.
Your Honor, this may be a good time to stop. I'm not going to be able to finish today, so if you wanted to, I'll leave it up to the court, but this might be a good time.
Your Honor, the problem is Mr. David is not going to be available after today. He's not available tomorrow. We made this clear.
How late, how much longer do you have?
Well, I can try to move quickly, but yeah, I mean, it's going to be at least, I feel like I'm being put in the...
No, I understand. Let me see the attorneys up here. Mr. David, it's 5 o'clock here. It looks like we may be a little bit longer with you. We don't know for sure. So what I need to do is figure out your availability for tomorrow morning. I was hoping, I haven't really run this by the jury yet. I was hoping to bring them in at 8:30. Is that possible for everybody for tomorrow at 8:30? Or do you want to come in a little bit later still?
Is it a full day tomorrow?
Yeah, we're going to go. I'm not. Actually, we were going really fast, and we were hoping to maybe finish tomorrow, but it doesn't look like that. I'll just be candid. We were hoping to maybe finish tomorrow. It looks like we'll be coming back on Tuesday. So I don't know if it will be a full day with you. We still have legal matters that we have to take up. What I don't want is you sitting back in the jury room while we take up a bunch of legal matters. All right? And so, so you may be going home early tomorrow, and we'll finish up all the other stuff, or it might be that we just come in earlier tomorrow morning. So let me first then ask, Mr. David, what's your availability for tomorrow morning?
I can be available tomorrow. I can be available tomorrow. I have to move some things around, and they're shutting the electricity off at my house tomorrow to put in some things in my home. So I thought originally I was not going to be available because I was going to be doing the Zoom from my house. So I will be available tomorrow because I'll be doing it from here again if you need me.
All right, 8:30. Does that work for everybody? You want to make it 9? 9 o'clock. All right. Everyone okay with 9 o'clock? And we're putting you out, so we'll work around your schedule. So I know I had mentioned earlier we always would start later because I have hearings every morning. On Fridays I don't. So we have this uniform motion calendar. So every morning from 8:45 to 9:30 I have hearings, but that's just Monday to Thursday. So I do have a full open day tomorrow, but we'll start 9 o'clock. All right, we'll give you let you sleep in a little bit later. So Mr. David, same drill as today for 9 o'clock tomorrow morning. All right, just to go ahead and log in, and so we'll all be here ready to go at 9 o'clock tomorrow. All right. Have a great night. So this is not your corporate rep, right? He does not work anymore for Celsius?
No, he doesn't. He's
Okay,
just the former
so I am going to instruct you during the break to not discuss your testimony with anyone. You're still in the middle of your examination, okay? All right, we'll see you tomorrow morning, 9 o'clock. All right, and with that, jurors, we are in recess. So again, these are my instructions to not discuss the case or have the case discussed in your presence. Do not do any investigation of your own. Have a great night, great breakfast, good night's sleep, and be ready up here, 9 o'clock, ready to go.
No eyes on the chairs, please.
Should I shut this off?
All right, so I'm going to go ahead and click end. All right, so you're gone. Turn that off here, so let's do this. It's been a long day, so I'll go ahead and break for tonight, but I'm going to give you all some homework, though, and that is what I would like is we'll finish up all those other witnesses. We'll obviously finish up Mr. David, and you have your other witness that was here today, so I'll let them know a little bit later, and then you possibly have another witness as well, right? So I think we'll finish up Mr. David, a couple other witnesses, and then we have to take care of all the instructions and verdict form. And so, if you all could let me know tomorrow where you're at with the instructions, so everything that's agreed, and then if you could highlight what their disagreements on. I think the other thing that's going to be difficult is going to be the verdict form. I looked, you all were completely different on your verdict forms. However, I'm hoping now you've been able to look at each other's and maybe come up with some kind of agreement. I do want questions that are going to address any of the legal issues. So the last thing we want is, if I do make a mistake, I don't anticipate on many mistakes, but you never know. District Court of Appeals sometimes tell me I get it wrong. What I don't want to do is have it come back and have to try the case all over again. All right? So we should have enough questions on there. Certainly we're going to preserve that the stock issue. And all right, so once we finish with all the testimony, I think then we'll have to take care of all the instructions, so we bring them back. So plan on Tuesday morning and then close arguments, all right? I think that's probably the best. And so then they'll have as much time as they want to deliberate. And in abundance of caution, if they don't finish in one day, we don't have to worry about, if they had started tomorrow, having to break their deliberations up by a 3-day weekend. So it probably works out better this way anyway.
I agree, and just can we count on that? Because I have a funeral in Boston that I will go to on Saturday if we're going to close on Tuesday.
Yeah, for sure we are not closing tomorrow.
Thank you.
There's zero chance. All right, so we'll, obviously depending on how things go, I'm sure we're going to get through these last witnesses, but you never know. If they have to come back Tuesday, they have to come back Tuesday. But I anticipate we'll be done with them tomorrow. So, all right. Everybody have a great night. We'll see you all here 9 o'clock. And anything else to take up, I should ask before we break. Have a great night.
We have to leave the courtroom, right?